With roll call.
Ryan Crawford.
Present.
Leonard Knapp.
Here.
Robert. Oh, sorry. Monty Montalongo.
Present.
Harold Parit.
Here.
With Simeon.
Here.
And Jared Reekey.
Here.
Has our newest commissioner been sworn in already?
He has, Mr. Chairman.
I want to take this opportunity before anything else to welcome you to the commission. We look forward to working with you for the betterment of both state troopers and the agency, as well as our state. So look forward to that.
Thanks, sir. It's an honor to be here.
Do you have a comment you want to make before we get started?
Just briefly, I'm honored to be amongst the ranks of the Louisiana State Police Commission. This is one that I hold in highest regard. And my commitment to the public is to serve on this board as a hardworking, fair, and ethical representative of the Louisiana State Police employees. I'm excited for the challenge and looking forward to working towards meaningful common goals.
Thank you. We'll start with a moment of silence.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, we've had some requests to speak to the commission on behalf of items that are on the agenda. Mr. Hack Willis has requested an opportunity to speak on item number 6 on the agenda. Self as well, but we know who you are. But
My name is Hackman Willis. I'm president of the State Troopers Association. I'm a sergeant with state police. I'm not the best at public speaking, so I did prepare some notes just to kind of help guide this along. But I thought it was appropriate to come to this meeting. I did not make the last meeting to address some issues that were brought up in the last meeting in public comments. So for those of y'all that don't know me or never met me, my name is Hack Willis. I come before you today in response to some insolent statements that were made at the May 12th commission meeting about myself and other representatives of the LSTA. I wasn't present at that meeting, as I said before, but I have viewed the recording and observed an individual come before you to allude that I had intentionally left a recording device during your executive session on the April 14th meeting. At first, I really did think that it probably wasn't worth the time to even respond to such a ridiculous statement, but especially since myself or the LSTA, we had no vested interest in what was being discussed in the executive session or what was going to be discussed in the executive session. The LSTA aren't even representing the employees involved in these appeals that you were hearing that day. We were there on that date to discuss the proposed commission rule changes that we're reviewing today on today's agenda. But later in the video, I saw where the same individual questions whether I could be trusted to answer truthfully about the incident. And at that point, I was just insulted by that comment. So to be clear, I don't know this individual. I've never had any conversation of importance with this person. This man knows absolutely nothing about me or my principles to make those type of accusations about me. I hope today is that this commission would not take those comments seriously. While I did leave my iPad at my chair when I left the room for the executive session, I did not and would never use that iPad or any other means to record anyone in this manner, nor did anyone else associated with the State Troopers Association. If the minutes are going to be adjusted to reflect that this incident took place, I trust that no commissioner would entertain accusing anyone from the LSTA of intentionally recording the executive session. And as this did not take place, and the minutes should not be memorialized in that manner. I appreciate you giving the opportunity to address the problem, and I thank you for the time and listening to our comments on this matter. Thank you.
Michelle Gerard. Yeah, that's what I was going to suggest. And same thing with Mary Ann White. Mr. Burns.
That one's not on the agenda, Mr. Chairman. So-
Oh, that's not on the, I'm sorry. This is item not on the agenda.
Well,
Into the
I
meeting.
have one that is, though.
Yeah, that's what I,
Oh, wait,
item 6.
I told you I was,
Yes.
I told you I was double dipping this time.
yeah, that's correct.
It wasn't my mistake.
I'm sorry.
At least this time it wasn't my mistake.
Well, it rarely is.
I'll ask my wife.
And I'll take just a couple of seconds to respond to the commentary that was just made. Well, I'm be very brief.
Extremely, please.
Yeah, I will. The individual is known to be me. I said, hopefully we can accept them at their word. I didn't accuse anybody of intentionally leaving it on. That's a misleading statement. I did add that we hoped that we could trust state police on a number of matters, and it turned to be out that we could not. That's as far as I went. But I will reiterate that nobody's a rookie at these meetings, and everybody knows the recording devices are to not be left in the room. I notice there's no denial of that. I'm done.
I've
That's-
admonished everyone about that already.
Yeah.
I think we.
Yeah, I'm
Needs to be dropped.
I'm fine with that. So that's the end of that part. Now, with regard to what I did want to address that's on the agenda, which is Circular 228 that's before you today. And in particularly, and I've had an extensive discussion, Mr. Hanneman called me about this, and I appreciate his call because he did clarify, he took full responsibility, particularly the portion that I'm going to, for lack of a better word, declassifies letters of reprimand to no longer be considered discipline. I oppose that measure on the grounds from, I believe any media outlet would state it's been very difficult to get public records. I mean, it just has. It oftentimes is like pulling teeth. And I'm sure most of you have probably followed the blog well enough to know that I have sued state police over the whole issue of these letters of counseling not being considered public record. We'll find out, I guess, a week from Monday when I will be arguing in front of Judge Don Johnson and making that point that no offense, but I do not believe this body has the authority to declare something not to be public record. I believe that role is relegated to the legislature, and I believe that's where it rightly could have been formally enacted by way of a statute to exempt any given record. And in this case, we're talking about letters of counseling / warning to not be public. I simply do not believe that this body has that vested authority. I'm very firm in that belief. If I'm wrong, I'm wrong. It won't be the first time. But my concern with what this proposal would do is that by declassifying, and that may be a poor choice of words, but it's downgrading it to not be considered discipline. I know what's going to happen. This too will not be considered public record. I think that we all know of one incident, and I'm sure you can remember it, Mr. Chairman. I'll go ahead and give the name, August McKay. That's what ended up happening from that whole episode. If this were in place, well, nobody would have had access to it. And I think that's a grave injustice to the public. I think it is an intentional effort to conceal problematic actions. And I'm opposed to it on that measure. If they wanted to stipulate that both the letters of counseling And I guess letters of counseling would largely become irrelevant if this measure passed, because now you've got a duplication that they effectively may as well be the same thing. That they are accessible to the public, because I do trust the public's ability to look at the infraction or the warning and the public make its own assessment of how serious it may be. Unfortunately, we don't have that latitude. So, and I've been told there's some pretty serious matters right now that have been handled by way of letters of counseling. The problem is I'm up.
One more minute.
Okay. Yeah, I'm pretty much wrapping up. Unfortunately, I can't substantiate that, because if I were to make public records, and I don't like going on just what I hear, I like to be able to substantiate something. And unfortunately, if I were to make public records requests, I'm not going to get them because of Rule 12.9, I believe it is. So with that, I would just like to emphasize my opposition for what it's worth. And I'm done, Mr. Chairman.
Thank you, Mr. Lawrence.
You're quite welcome.
Willis, your request to address the commission on General Circular 2228, you'll be doing that as a representative of the LSTA. So we'll defer that until then. Other than persons who want to speak specifically on agenda items as parties, those are all the requests we had to address the commission on items on the agenda. We do have one additional request to address the commission on an item not on the agenda that we'll take at the end of the meeting, and the others will address. Yes, sir.
Excuse me, Mr. Chairman. My name is Ashton O'Dwyer. I am a disbarred, humiliated, embarrassed, and disgraced lawyer by education. My agenda item is the last one on the commission's agenda for today. Mr. Hanneman was unable to tell me earlier in the week whether or not the commission would grant my request to speak for more than the customary 5 minutes. And because he was unable to do that, it was necessary for me to put my submissions to the commission in writing, which I have delivered to him and signed. There's a copy for each of you, and there's a copy for Ms. Givens. I am prepared at this time to deliver my remarks and make my presentation. However, I recognize that there is some very high-priced legal talent in the room, and the meter is running. So if you all will indulge me, I can speak at the end after all of these high-powered attorneys who are not disbarred have made their presentations on behalf of their clients. I will do whatever the commission wants me to do. Thank you.
We were going to have you speak when your item came up later in the agenda.
Thank you very much, Mr. Chairman.
Thank you.
My remarks will take about 20 minutes.
Just bear in mind, if you submitted them in writing, I mean, we have read and/or will read everything that was submitted, and so we would ask that you reduce that time, but we'll get to that when we get to
Thank
the
you.
agenda item. First order of business is consideration of the meeting minutes from May 12, 2022. You have a motion.
Mr. Chairman, I would move that these be accepted.
Moved by Commissioner Knapp. Do we have a second? Like a second by Commissioner Perry. All in favor?
Aye.
Any opposed? The ayes have it. That's all of us. Anyone have any discussion? Before we vote? Okay. All in favor?
Aye.
Any opposed? Okay. The second item of business is consideration of a request from the Office of State Police for a 2-year reauthorization of 18 part-time WAE positions. And I understand we have a representative from State Police here to speak to us this morning. Good morning. And we know who you are, but for the purpose of the minutes, would you identify yourself?
Good morning, Mr. Chair. Good morning, Commissioners. Shavaz Cameron, Deputy Superintendent over Patrol, Louisiana State Police. Just wanted to say also congratulations to a newly appointed Commissioner, Sergeant Montalvo. Appreciate you and your representation and all that you have done and the expectations moving forward. So we look forward to working with you as well. Mr. Chair and Commissioners, as you know, we have been postured here lately to do a lot more with less. Our personnel has been tremendously decreased, and we are in a position now where we do require the assistance of these WAE positions that are being requested and one that's being asked to be approved for newly proposed position today. I stand before you seeking your request and your reauthorization approval for some 17 that are listed, and there's one that is listed as a new proposed WAE position. All of these positions, and I can answer any questions in particular for any one of them that you may have today, but in particular, all of these positions are very critical and vital for Louisiana State Police and the continuation of our mission to continue to provide an efficient and effective operation and provide safety for our citizens of Louisiana. I just asked again for your approval and consideration or reauthorization of the 17 and the one that is a request for a newly proposed one, that it also be considered for approval.
Well, on behalf of the commission, I do want to say we're glad you're here and can answer those questions. And we do understand why there was not other ranking officials here from State Police last time because of what was going on with the graduation of the class.
Yes, sir.
But when we have an item like this, if we have to defer it to another meeting, let's make sure we have somebody who can answer the questions that we have so that we can make an informed decision on these items.
Yes, sir, Mr. Chair, if I could, on behalf of Colonel Davis and all of our staff, we apologize for that. Again, we'll work to make sure that doesn't happen again.
I know you will. But why don't you briefly give us a summary of not each one, but a summary of why it is these are necessary, what the various areas are. Whether I'd also like you to address in that summary whether or not, even though if we do approve, I think it's a 2-year extension you're all asking for, if manpower allows you to decrease that number before that 2 years is up, what the plan would be.
Yes, sir. Thank you for that opportunity to explain it. And I'll be very brief on these. 2 in particular represent or come out of the request for our troop. At our troop levels, we are, especially like at Troop G, we're at critical minimum staffing levels. And a position such as the WAE position that's on the request today, that position allows us to free up some of our desk supervisors. This particular WAE assists with administrative duties as well as a ton of physical inspections that come through the troop. The one particular one in reference to Troop I, that troop request is because of a WAE that we have that we're using to alleviate our XO duties with the evidence handling. So that's very critical and important. Several other ones that are falling under our motor carrier division program. All of those are, if you see in the briefing, all of those are federally funded, Mr. Chair and Commissioner. So they actually serve a vital function for us. And listen, we do understand that the WAE program is a short-term goal right now. Our long-term goal is to continue to work to fill the ranks of our department. And as you know, we just graduated 51 from Cadet Class 101, and we are anticipating Cadet Class 100. Cadet Class 101, we're anticipating the commencement of that here in July 31st. So with those considerations, we are looking every day to fill these in a long-term role. However, because of the personnel shortage that we're dealing with, these positions are critical today, and it's hard to fill them with a full-time personnel. And that's why we're looking to continue the approval to have them extended for 2 more years.
I still didn't, and maybe I missed it, but didn't get an answer to the question. If personnel allows you to eliminate some of these WAE positions before this 2 years is up, what is the intent?
Yes, Mr. Chair, that's absolutely our intention to reevaluate those positions as the need or the position, other personnel come on board. We will reevaluate those. And again, as I said, this is a short-term fix. And I believe that every WAE that are in these positions understand that at any given moment, those positions are subject to be turned over.
Yeah, just a quick comment and follow up on these positions. I was contacted earlier this week by a couple of troopers, actually, based on the fact that we're short troopers right now. And I know we've got an accelerated basic training class coming up. Is that correct?
Yes, sir.
Okay. And in that basic training class, I think the stipulation for hire for the training class was that they have 2 years post-certification prior to some deadline or the class starting. Is that right?
That's correct, sir.
Okay. What I was told was that there were a handful of applicants, up to 4 to 6, that possibly did not make the deadline for the 2-year post-certification, but were within the 2 years post of the actual basic training class starting. And so a couple of these individuals were up in my district in Northwest Louisiana. And so one of the individuals actually received a letter that they had been accepted into the class. Their sheriff had been contacted by someone in the State Troopers Association or authority and said, "Hey, we're taking one of your guys." So they call the young man in, the deputy, and say, "Congratulations, you've been accepted." And he said, "No, they're not taking me." And they said, "No, we just talked to them on the phone. They're taking you, and you got your letter." He said, "No," he said, "I'm 6 days short from the deadline that was implemented, but I'm over my 2 years from the time the basic training class is actually going to start this month," which seems incredibly short-sighted for somebody. They said it was going up the chain to see if they could get some type of, authoritative, waiver to allow these individuals to get into the basic training class. And I thought, if it's all true, as short as we are of troopers right now, we have people in leadership and authority positions in the state troopers, that have to make these decisions on the fly. So it's not black and white. And if we're this short and we have a handful of applicants that do meet the minimum requirements by the time the basic training class starts, it really seems like to me somebody along that chain that was making the decision on, are we going to take these individuals or are we not, should have said, "You know what? We need to let these individuals in because we're short. They're going to meet the requirements before the training class starts." And, and I have a problem with that if that's how it unfolded. And I would like somebody to look into that. And that goes back directly to this. I mean, if we've got law enforcement officers who are wanting to join that meet that requirement before the training class starts, I think by all means, they should be given due consideration for beginning that class, especially as short as we are.
If I may, Mr. Commissioner.
Absolutely.
First, thank you for making me aware of that. I can't speak on anyone else on a senior level that may be briefed or not be briefed on it, but if you would allow me the opportunity to look into it. But I'll say this, that there's no secret that we're looking for the best and brightest and most qualified that are eligible to apply. Coming out of the recruiting division years ago, we set timetables in place and there's deadlines for reasons that the phases to go through the hiring process are tight because of all the mechanisms and factors that go in place, such as testing, physical assessments, the matrix examination that we have to also look at. So I don't know in particular for the 4 that you're speaking of. I would be glad to get the names, look at it, but I can tell you without looking at it, there are deadlines that we have to set in place to meet the other factors that are part of the almost 8 phases of the hiring process.
Right. And listen, I completely understand that. We went through the same thing when I was fire chief. It's a very strict process. But I think in looking at this, these individuals were allowed to go, from what I understand, from what I've been told, they went through the entire process, the physical agility test, the testing mechanisms, everything. And we're going to be hired until the very end. And then somebody said, oh, well, you don't meet the 2-year deadline requirement from this date, not when the basic training class started. And it seems to me like they should have never even been allowed to go through the testing process and have to put all of this good faith effort into, the process itself, pass everything, and then told at the end, oh, by the way, you don't make the 2-year requirement for this cutoff date, not the starting date for basic training. So I've got some questions about why they were put through the process and then kind of, it looks like the rug pulled out from under them at the end. And like I said, this is just what I've been told. So I appreciate you looking into it and getting back to me.
Definitely will. If you would allow me to do that, we'll have a
Absolutely.
response for you.
Thank you so much.
Thank you.
Mr. Chair.
Yes, sir. Commissioner Knapp.
I think I was the one who asked the question last time about the number of WAE positions are actually in the available in the Louisiana State Police. And you've given me that answer here of 71.
Yes, sir.
And according to my calculation, that's about 7.15% of your total positions that you have that are currently in existence. And I know that we are still looking for additional troopers out there. So I think I'm very appreciative of those persons who are willing to step up and continue serving the public in this capacity. So with that in test, I would move that we approve the request of the Louisiana State Police for the 2-year reauthorization of the 18 part-time WA positions that are set forth here.
Move in multiple seconds. Any other discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Thank you. Appreciate it, Commissioner. Chair.
Matter of Brittany Pierce, Department of Public Safety and Corrections, State Office of State Police, docket number 22-262S, discussion of a proposed settlement agreement and presentation by the parties.
Morning, Commission members. I'm Michelle Giroir on behalf of the Department of Public Safety, Office of State Police. If you have any questions about the settlement agreement, I'll be happy to answer them.
And good morning, Commissioners. My name is Mary Ann White, and I am standing in for Floyd Falcon, who actually represented Ms. Pius in this matter.
Anyone have any questions for any of the parties? Okay. In a motion to move into executive session to discuss allegations of misconduct. Second. Commissioner Knapp, did you have a comment before we voted on that?
That's fine.
Go ahead and take a roll call vote.
Brian Crawford,
Yes.
Leonard Knapp,
Yes.
Monty Montalongo.
Yes.
Harold Parit. Yes. Jared Ricky,
Yes.
Beulah Simeon.
Yes.
We're now in executive session.
Won't repeat the admonition from previous. All we're doing is, yeah,
I'll make a motion to exit executive session, come back into.
I'd second it.
okay. Roll call.
Ryan Crawford,
Yes.
Leonard Knapp,
Yes.
Monte Montalongo, Harold Pereira.
Yes.
Jared Ricky,
Yes.
Eula Simeon.
Yes.
We're now back in regular session.
I'd like to recuse myself from item
6-3.
6.3.
Same difficulty in calling the number, so don't worry about it. All right. That's fine. You can self-recuse yourself. All right, then we have a motion to go back into executive session.
I'll move that we go back and.
Moved and seconded, roll call.
Ryan Crawford,
Yes.
Leonard Knapp,
Yes.
Harold Pereira,
Yes.
Jared Ricky,
Yes.
Eula Simeon.
Yes. Sorry.
Executive session.
back on. Entertain a motion to leave executive session.
I'll move.
I
Been
would second.
Moved and seconded. Any discussion? Take a roll call vote, please.
Brian Crawford,
Yes.
Leonard Knapp,
Yes.
Harold Reed,
Yes.
Jared Ricky,
Yes.
and Eula Simeon.
Yes. Even though he was recused from the motion, I think he voted on he didn't vote on the executive
Not on the
session.
last one,
Oh, okay.
regular session.
All right, thank you. Any motions before we move to item 4 on the agenda?
Mr. Chairman, in the matter of Brittany Hyas, and docket number 22-262-S, I would move to approve the proposed settlement agreement presented by the parties and accept that proposed settlement agreement.
Second.
Been moved by Commissioner Knapp, second by Commissioner Fareed. Any discussion? All in favor?
Aye.
Aye.
Any opposed? Okay, the ayes have it. The settlement agreement has been approved. Any motions before we move into item 4 of the agenda?
Mr. Chairman,
Yes, Commissioner Crawford.
make a motion that we combine matters 6.4 and 6.5, just because of their correlation to one another and our ability to conduct business more efficiently and hearing those matters at the same time. I would second that.
It's been moved and second. Any discussion? All in favor?
Aye.
Aye.
Any opposed? The ayes have it. So we'll proceed with items number 4 and 5, and I will announce both of those in just a second on the agenda at the same time. There are 3 different parties involved in the various motions. So we'll hear the arguments on all of those. But what I ask the moving party to do is to discuss one party's, let that party respond, discuss the next party, let that party respond, and then third. Okay. All right. So I'll call item number 4 in the matter of Cavalier, Department of Public Safety and Corrections, Office of State Police, docket number 21257S. Motions to quash, eliminate, and or recall subpoena and or subpoena deuces tecum, and motions to eliminate filed on behalf of Kevin Reeves, Jason Turner, Office of State Police, and or Carl Cavalier. And also docket number 5, consideration penalties for contempt of the commission held over from May 12, 2022, State Police Commission meeting. So Ms. Feeney, I'll let you direct the order that you want.
Let's start with Mr. Kevin Reeves.
And if I may, sir, the subpoena issued by Mr. Reeves specifically requested a number of documents. We filed a motion to quash the subpoena, frankly, out of an abundance of caution, because we have an existing federal civil rights lawsuit in the Middle District. I've discussed it with my client, and as to a number of items, we would like to go ahead and respond and provide the documents as per the subpoena to the commission. And I think honestly, they're going to be dispositive of the motions that you're about to hear. And certainly they're going to be considered, I would hope they would be considered in conjunction with the motions to quash. For the record, one of the items that Mr. Reeves subpoenaed.
Yes, yes.
sir.
We just started talking. Nobody even asked us to introduce ourselves.
Well, this is because you're so well known, Mr. Owens.
Last time there was an issue that we weren't here, so we're
Your your presence is noted, but go ahead and,
Would be
Mr. Oglesby,
seated?
identify yourself.
Please be seated,
Kevin Reeves.
All right, thank you.
everybody.
Can we be seated?
Yes.
As stated, Mr. Reeves had subpoenaed my client to produce recordings he's made of other state troopers. I have those recordings and I have a copy for the commission. It consists of 5 or 6 recordings, is that right? Including recordings which bear directly on the motions in limine filed by Mr. Turner, the motion to quash, the motions in limine by the state, and the motion filed by Mr. Reeves. My client can better describe each recording. Secondarily, they asked for copies of Albert Paxton's notes that my client possesses. I have those too, which I'd also like to provide to the commission as well. In addition to the notes that my client received from that were Mr. Paxton's notes, there is also, I believe, to be responsive, some emails by then LSP legal counsel Faye Morrison that were sent to Mr. Paxton, Johnny Brown, something about an aortic rupture information. And at that time in November of 2020, going back and trying to reconstruct the accident, they had also asked for production of all pictures, postings that reflect photographs of my client using Elijah Steele. I've produced what we have. My client began using the name, which he can testify about, Elijah Steele in 2014 and 15, when he adopted it as a pseudonym.
I just have, before we go further, I just have a question for you.
Yes,
When
sir.
was it that the decision was made to comply with the subpoena rather than to proceed with the motion to quash?
My client is a long haul trucker. And so I was able to meet with him this morning at 6:30 in my office. We've spoken on the phone on and off about it. He and I went through the document production. We had put them together in the event the motion to quash was not ultimately successful. So to answer your question, once we kind of got everything together and had an opportunity to discuss this morning, that's when we made the final decision.
So why didn't the parties get together before this hearing and discuss the fact that you're no longer proceeding with the motion to quash and you turn over the things and then you turn over to us, whatever you, instead of waiting for this hearing to start doing all this presentation right now?
Well, to be fair, I wanted to make sure that the documents I turned over were on a public record. And then my understanding is the documents are produced here to you and for your dissemination to Mr. Reeves's counsel. That's what I want to make sure that that's clear.
Okay, we have an attorney that generally handles the stuff outside the context of our meetings. So get with Ms. Feeney next time so that we can have this handled. And certainly if you need to make a record, I'm not opposed to you making a record, but right now we're going through a lot of stuff that I think could have been handled beforehand.
Well, I understand that, sir, but unfortunately, my client was not in a position to meet with me in person until this morning. And that is a discussion that I think is important to have with him in person, which I did.
Don't doubt that. We started at 9 o'clock. If we needed some more time, if someone would have asked, we could have deferred some time. Let's finish this because we're spending more time
Sure.
talking about it.
So in the document production, it's the Ronald Green notes, also the emails from Faye Morrison. There's also an email from a Scott Wollison dated September 5th, 2020 to Kevin Ducote, as it relates to Master Trooper Hollingsworth for an interview. They asked for documentation relating to that. I have emails from Draper Crane, who is my client's lieutenant, as it specifically relates to the book. I have correspondence that my client sent to Mr. Reeves on September 11th, 2020, and Governor Edwards relating to his complaints of racism and his complaints as it related to the Ronald Green situation. There are a series of emails that were sent to Mr. Reeves before his retirement on October 30th, 2020 on behalf of my client, which specifically raised the issue and my client's concerns that Ronald Green and that situation was being covered up in addition to racism. I also am producing, because I asked the state police to run a search on Toussaint Louverture, which are the name that my client used, in addition to NWB and some other terms, Ronald Green and those types of issues, and Elijah Steele. The state police returned to me on May 27th, 2022, a number of the Toussaint Louverture emails, which was also, I believe, requested in the subpoena. So those are my returns. And those documents, the only other thing that I would note for the record with respect to our remaining considerations on the motion to quash is being mindful of the fact that my client does have a federal civil rights lawsuit. And I would like to make sure that this body is not being used as some sort of attempt to conduct discovery on a federal civil rights claim before we're allowed to do that within the confines of the federal court. But I think honestly, these documents are relatively dispositive. I would like my client to identify for the record the recordings since he made them and who they are of.
Do I get to say anything?
Well, she's just making a production right now, but
Okay.
we need a testimony.
I want it.
I would like to know what is.
Okay.
Yeah.
Can you stand up and tell them what's on the
If he
recording?
testifies, you can question him.
Expect him to sit over
Yeah,
here.
you wanna
where
come over
witnesses
here?
are.
Those meetings, it's my expectations that matter.
I don't have them.
I'm sorry, Judge.
The recording.
I just don't, I don't know what kind of procedure we have here. I wasn't prepared for us to be prepared. I apologize.
I understand.
You want to just ask him to identify, maybe that would be,
I think I did everything except the recordings.
Yeah.
Which he's going to talk about what he recalls in terms of who he recorded and the content.
You don't have the dates and things. Okay.
Just do your best.
Okay.
Pardon me, am I gonna get a copy of these? I'm the one that issued the subpoena.
you have,
Sure.
okay.
I do.
And I have a different question, maybe because I wasn't listening well enough or couldn't hear. Was there an issue of whether these are or not public records?
I'm not aware of that issue being discussed before the
Oh,
commission.
okay. I thought Ms. Craft brought up that. there was
You
some-
requested the document. She filed a motion to quash, and today she's saying that she's producing the
Right, I got that
documents.
part.
That's as
Okay.
far caught up as we are.
Thank you. What? What is this?
That's the reason he's on the stand, is to tell us what's on the recording.
Okey
You
doke.
can just hold on a second. We'll let Mr. Cavalier tell us. Yep, go ahead.
So good morning. The recordings that we're speaking about right now are recordings, phone recordings and in-person recordings of myself and individuals within my chain of command, outside of my chain of command, and troopers as well as it relates to the investigations that were ongoing into me and disciplinary actions taken against me in reference to the book I wrote, NWB, in reference to me speaking out to the media. So those recordings were conversations from Trooper Troy Pichon, Trooper Leander Journey, Colonel Van Buren, and I think that
Mr.
covers
Sims? Sam, sorry.
Byron Sams.
And Dakota.
And Kevin Dakota, which is an IA interview, internal affairs interview. Byron Sams is was the EEOC officer at the time. He and I had an extensive conversation in relations to the claims I was making as far as discrimination goes and racism within the department, and also the Ronald Green case as well. Should I go far into detail about the recordings? I mean, they have provided to them. I mean, I don't know how far you guys want me to go
I think I
into.
just wanted you to identify what recordings you had made.
Yeah.
Are there dates on the recordings to
There-
tell us when these recordings were done, performed?
There
rec-
are.
The
which I don't-
recordings are dated, and I believe they're timestamped as well, and the duration and length of the recordings as well. So not to go too far into it, I as I said before, I provided, and we have more copies to provide to all the members as well. But just for an example, after I was put on the initial enforced leave, after there was a command hearing, a command meeting about me writing a book, I was put on enforced leave, and the reason given
for me put on enforced leave was because I stated that I was stressed because of the racism within the department and the things in reference to Ronald Green going on. So that was the reason that the department gave to me for putting me on enforced leave. But there was a meeting prior to me going on enforced leave about my book. So I recorded the conversation when Leander Journey gave me a call saying that, and I quote, someone from the administrative staff said for you to lay low, keep your mouth closed, and everything is going to be all right. And I got a call from sorry.
This call that you just related.
That call was in June, and believe that was on the 4th, and the call from
June of what year?
2021.
June of 2021, is that what we just said?
Correct. It's dated on a flash drive for you as well.
Could I make just a request?
You can make a request, certainly.
I'm trying to understand exactly, this gentleman is given a speech. There are no questions being asked of him. It's on a motion to quash and a motion to recall the subpoena for Colonel Reeves. And I appreciate all this information he's providing to me. None of it that I see relates to anything to do with the issues before you guys and today.
Well,
So,
I can get to that.
Pardon me. Presume I'm gonna get to cross-examine this gentleman. And I want to make sure that's true before he gets to just keep giving these free-flowing statements on his own behalf. Is that correct?
As I indicated to you earlier, Mr. Ombudsman, if he testifies, you'll have an opportunity to examine.
Okay, thank you.
And really, I think we only wanted to know what's on the tape
Yeah.
so that a decision can be made about what we're doing in terms of the decisions today. So if you want to ask questions about who's on the tape at the time, let's do
I'll
that.
get
And
to
then,
'em.
and then
I
we'll
just
have,
wanna
and then we'll be through and have.
Figure out
argument.
where we are.
You want to ask any questions about?
But when he
what's
gets
on the-
finished,
You know, it's,
I didn't
go
mean to
ahead.
interrupt him. It was
I think he
apparently-
gave us the names and the dates sufficiently. So if you want
Well,
to.
I don't know if his lawyers, I don't know if, is it my turn? Are you tendering the
I'm
witness?
trying to
Not you,
say,
Ms.
you can
Phoenix.
ask questions now if you'd like to.
Okay, great. Mr. Cavalier. I don't know if the committee has any of this, but they just gave me a date, some document dated May 27th of 2022. And it has 3 recordings on it. In the year, pardon me, 2 recordings on it.
Can I show
One
him the
of-
document?
Yeah, it's
Yeah.
from you.
Yeah, it's not recordings, it's emails.
Okay, 2 emails, one October 16th, 2020. Under the name of Toussaint Lavateur. What day did Kevin Reeves stop being the colonel of state police?
I think that's established. We know when we stop.
I know we do. I don't know if he does.
Well, it doesn't matter what he knows. It matters. what
Okay,
we-
fine. Sir, let's get to it. Your lawyer issued a subpoena for Kevin Reeves and asked him to be held in contempt of court for not coming here. All right? How many times have you, Carl Cavalier, spoken to Kevin Reeves?
Can't recall the amount of times, but I've spoken to him, I'll say a few times.
Really, where and when? About what?
At the Capitol, I have pictures of that, video of that.
No, I'm sorry. Let me be more precise.
Oh,
in
go
my
ahead.
question. While you were a state trooper and Kevin Reeves was the colonel, prior to October 9th of 2020, how many times did you have meetings and discussions with Kevin Reeves?
A few times
Where?
at the state capitol.
With whom? Who was present?
Doug Kane, Kevin Reeves, House members, Senate members
At the state capitol.
at the state capitol.
All right, so just tell us, was that in this year?
That was not in this year.
Was it in last year?
No, sir.
So these are meetings you had, were they about the Ronald Green case or anything to do with your discipline?
No, sir, they weren't.
Were they just congenial, hi, how you doing? Kind of meetings?
It was in reference to me being honored for receiving the Medal of Valor.
Okay, so let me be very precise in my question. How many conversations did you ever have while Kevin Reeves was the colonel of the state police that represent any of your complaints about the eventual 200-hour suspension you received from Colonel Davis?
Well, the conversation that I'm referencing, or the communication that I'm referencing, and the reason that he's here is because of a letter that I wrote from myself to Kevin Reeves, the governor, and other state police officials at the time, which Kevin Reeves said that he received from Representative Edmund Jordan.
Hold on.
Mr. Imes, can you
Mr.
keep that?
Oglesby, just 1 second, please.
Got an extra copy.
Give it to him. Give it to them.
We have it.
I'll have these.
Mr. Cavalier, I would direct you, answer the question that's asked of you, and if you have an explanation for that question, then you can give it, but you'd have to
All right,
first.
Mr.
Ms.
Cavalier.
Oglesby, I was in the middle of talking to the witness. You have to first answer the question, okay?
Okay.
All right, Mr. Oglesby, you may proceed.
Sir, are you talking about this letter? Starts off at the left-hand top corner, black Louisiana State Troopers.
That's correct.
Okay, and I apologize, but my copy doesn't have your name anywhere on it.
Okay. So that's the explanation I was going into about the letter being delivered to Kevin Reeves and also to Governor Edwards by Representative Edmund Jordan, and at one of the not committee hearings, but at the legislative hearings that we're having into the investigation around the Green case. Mr. Kevin was being interviewed by the members of the committee, and he acknowledged the fact that he received a letter from Edmund Jordan on my behalf.
Hold on. Hold on. Let's be crystal clear. The reading of that transcript is that Edmund Jordan identified you as a man named Toussaint Levateur, never called Cavalier. Have you, as called Cavalier, ever signed anything, sir, sent to Colonel Reeves regarding any of your complaints preceding October 20?
I'm gonna correct you on the legislative recording. Mr. Jordan did identify, Mr. Jordan addressed this letter that is addressed Black Louisiana State Troopers and asked Kevin Reeves, did he receive it? He said he remembered receiving it. To follow that, what you're speaking of, Mr. Jordan, to follow that, Kevin followed that up by saying that he knew of some emails of Toussaint Louverture, but he didn't find out that it was me until later. That's what you're referencing.
All right, let's just quit worrying, dancing around it. Sir, have you ever used your name, called Cavalier, in any communications while Colonel Kevin Reeves was the colonel that you want to show us today, ever?
Yes, you're looking at it. The Black Louisiana State Troopers letter. While it may not have my name signed on it, give me a second. While it may not have my name signed on it, it was understood between myself and Representative Jordan. We met up in person. I gave him this letter September 12th, 2020, prior to Kevin Reeves' resignation. He delivered the letter to the governor, and in response to that, Representative Jordan, a few days later, asked me, he said, hey,
Excuse me,
No,
gentlemen.
sir,
we just-
let me finish, please.
No, I'm not, pardon me.
Ms. Oglesby, Ms. Oglesby, I rule.
That's why I'm
all Ms.
asking.
Feeney rules. If you got an objection.
I do.
Okay, what's your objection?
Hearsay, all of this. And I don't know the rules here, so that's why I don't know what to do. His discussions of what Edmund Jordan did or didn't do and who he's talked to or didn't talk to, he wasn't a party to, and that's hearsay. Now, I don't know if hearsay is allowed, so if it's an improper objection, okay. But it is hearsay.
I just want it to be an objection, Mr. Oglesby.
Objection, hearsay.
Sustained.
Okay.
Sustained.
However, I would like to respond before it's objection and sustained. We are here on the issue of whether or not Mr. Reeves should be asked to testify. Mr. Oglesby subpoenaed these documents, which I produced, and the recordings from my client. That was the subpoena return I did, noting, however, that my client has an existing federal civil rights lawsuit. The question, as I understood it, was limited to what's on the recording. Now we're getting into what does he know and what is his basis for asking Mr. Reeves to come. Hearsay is permitted in the confines of these hearings. In fact, I think your rules provide that there shall not be strict adherence to the rules of evidence. To the extent we're here asking this man, why did you subpoena this man? I think he's entitled to ask that. And whether or not you ultimately at his trial determine that he's true, or Mr. Jordan comes and testifies and said, that's exactly what I told him. But I understood the predicate for today's hearing was, what is the basis for calling him? And that's what he's trying to tell you.
Yeah, we're gonna go ahead and let him testify under those circumstances so that we can
Limited to
limit.
the purposes of this hearing.
So to finish my statement, Representative Jordan, after delivering this letter that we're looking at to Governor Edwards, in turn, Governor Edwards asked through Representative Jordan, what did I wanted to see done in relation to all these things that I've mentioned here in this letter. So to answer your question, sir, my name wasn't signed on this letter, but it was understood from myself to Representative Jordan, to the governor, and to whomever else he delivered the letter to, that was from me, because the discussion was about me.
Cavalier, why didn't you sign your name?
I didn't feel it necessary at the time to sign my name because I was speaking for myself, on the behalf of myself and on behalf of Black Louisiana State Troopers that I had discussions with around the department.
Black Louisiana State Troopers, and give their names, approved you're sending this letter.
Well, I'm not saying that anyone approved of me sending this letter, but the people who I spoke to agreed with the sentiments here in this letter.
How many? Isn't there a Black Louisiana State Troopers organization?
I'm not a part of that, sir.
Huh?
I'm not a part of that.
I don't care if you're a part of it. Please, can you say yes or no, there is?
I believe so, yes.
Did you approach them with your concerns and desire to write a letter to Governor Edwards on behalf of Black Louisiana State Troopers?
I was not writing on the behalf of that organization at all, sir.
Who gave you the authority, sir, to write a letter on behalf of Black Louisiana State Troopers, of which I understand there are quite a few hundred? Who gave you that authority?
I didn't think I needed authority for anyone to write a letter, sir.
All right. But why didn't you then sign your name?
I answered that question.
Would you mind answering it again?
No, I don't mind. I didn't feel the need to sign my name to the letter at the time because I was speaking on behalf of myself and behalf of others who I've spoken to throughout the department.
Do you have, sir, where is a document that Colonel Kevin Reeves is advised on September 11th or thereafter, before his retirement the following month, that the person writing this letter is a guy named Carl Cavalier?
You asked me for a document.
Mm-hmm.
The document is in front of you, sir.
No, that Kevin Reeves is advised that Black Louisiana State Troopers is Carl Cavalier. You have such?
Well, your client, Mr. Kevin, spoke to that during the interview of the legislative meeting.
Sir, I'm sorry. I may take too long to ask a simple question. Prior to October 31, 2020, have you any proof, sir, that Carl Cavalier, the man's name, Carl Cavalier, was provided to Kevin Reeves as the author of this document?
Yes, through the ways I just explained to you, through Representative Jordan and the governor.
Have either Representative Jordan or the governor said, we told Kevin Reeves that you, Carl Cavalier, wrote this letter? Have either one of those men said that, sir?
They didn't say that to me, no,
No,
sir.
they haven't. Now, let me ask you a different question. You then gave us a stack of emails. Toussaint Laboratory. Who's he?
Toussaint Louverture is a Haitian general, or was a Haitian general who led a slave revolt.
Why didn't you put Carl Cavalier?
I like the name Toussaint Louverture.
Did you tell Colonel Reeves, I'm going to use the name Toussaint Louverture, but if you want to talk to me, call me up. I'm Carl.
I didn't think the name was important as the things I was alleging in the emails as far as cover up and the murder.
All right. Now, you gave me two. So at no time, you have no proof today. Or perhaps a better question. You agree with me today that you never identified yourself as Toussaint Louverture, nor as the author of the Louisiana Black Louisiana State Troopers letter to Colonel Reeves while he was the colonel of the state police.
No, I do not agree with you.
Well, then tell me, when did you identify yourself to Colonel Reeves while he was the colonel of the Louisiana State Police?
This is like the fourth time I'm answering this question.
I hadn't heard anything but about Edmund Jordan and him talking to each other. I hadn't heard anybody say they talked to Colonel Reeves.
He's going to answer the question, Mr. Alexander. Let's keep it going.
Okay, through the ways and the means that I just explained, this Black Louisiana State Troopers letter went through Edmund Jordan to the governor and back to me with a correspondence from the governor asking, what do I want to see done from this?
I understand. Okay, that's your answer.
Mhm.
Now, sir, you've given me this list at least reflects 2 tape recordings that were made before.
So we can be clear, those
Pardon me,
aren't
I'm-
tape recordings, those are, I asked state police in advance of his subpoena to pull all Toussaint Louverture emails from their server. That's what that is. I just want to make sure that's not to be confused with the recordings of other troopers, which is a separate return.
I misspoke.
We got it.
Okay.
Go ahead.
You gave me 2 emails, one of October 16th, 20, one of October 29th, 20, made by Toussaint Louverture. Are those the only 2 emails that were sent by you to Kevin Reeves or to multiple people, including Kevin Reeves, while he was the colonel of the state police?
About this matter. The
About
only
anything.
emails about anything. You're asking about anything.
I'm not sure. The dates here are the dates I can recall right off the top of my head, but I'm not sure if there were any other emails sent prior to that. But I can say the fact that that there were monthly or weekly staff meetings while Colonel Kevin was in office, into the leaks at the time, and at the time the leaks was myself, into the leaks about the Ronald Green incident and surrounding the Ronald Green incident. That was myself, and Kevin Reeves is the one who set that in motion.
Sir, have you got for us today a shred of evidence, single witness, a piece of paper, a tape recording, an email, or your own personal interaction with Colonel Kevin Reeves where the name Carl Cavalier is ever uttered?
Yes, the tape recordings. Be recordings from the legislative body where other troopers came in and gave testimony saying that under Kevin Reeves, they were given direction to find out who was the leak, who was the leak, and how was the information getting out.
Sir, y'all heard my question. Can you answer it, please?
Yes, I think it did.
That's your answer?
That's my answer.
So you rest on whatever is in the documents from the testimony of Mr. Oliphant, Mr. White, and Mr. Barnum, which the committee has been given by me. You're saying that in those documents, that testimony, you believe those men say that your name was used.
I didn't say that. That's not what I said. What I said was that they were given direction to investigate the leaks at the time. And at the time, the leaks were myself.
Well, before Kevin Reeves left on October 30th, 2020, what discipline had he administered to you?
So unauthorized use of department's vehicle, I believe, and one other disciplinary action.
Unauthorized use of a department vehicle had to do with you taking your car to New Orleans to go to the barber's training and meeting with your lawyer and at a hotel in New Orleans and having lunch in the French Quarter with a friend of yours. Is that event?
No, that's inaccurate, sir.
Is that the one time that you got a 12-hour suspension during the time Kevin Reeves was a colonel?
Mhm.
All right, now.
But just to make clear, you added some stuff to that discipline, and which I still contest to the day.
Okay,
That's
fine.
inaccurate. So
Regardless, we brought this up. The last time we were here, we didn't have that. We weren't as educated as we should have been for the committee. Isn't it true that Mr. Mike Noel, not Kevin Reeves, administered that 12 hours? Documents speak for themselves. Don't you recall that to be true?
no, I don't recall that to be true.
Do you want to say that you met with Kevin Reeves?
Met with him for, I'm unclear what he's saying. I'm unclear what question you asked.
Okay. Did you appeal that 12-hour discipline?
I was told at the time that I couldn't appeal that discipline, and also for that discipline, I was told I can write a letter contesting that discipline, saying that I don't agree with it, and put it in my folder, which I didn't.
You did not write the letter. Okay, but did Kevin Reeves tell you that you couldn't appeal the discipline?
No, he didn't.
Did you even meet with Kevin Reeves during the entire time you were a state trooper for any reason at all, other than a mass address by the colonel to the troop?
I don't remember meeting with him, no.
All right, now, you've also put down this case that these gentlemen are hearing. It's a specific case number, and it's about a 200-hour suspension. Who gave you that suspension?
It was, the final decision was made by now Colonel Davis.
All right. What evidence have you that Kevin Reeves accumulated any information that led to your suspension?
The start of my suspension and the start of these investigations, which led to my suspension, in my opinion, and from the way the letter and everything was delivered, on behalf of myself and other troopers, it's my understanding that Mr. Reeves set all of that in motion. Said he may have retired prior to the finished product, but my understanding that he set all of those investigations in motion.
Investigation of what exactly?
Investigations into the leak.
Into a leak.
Into a leak,
Okay.
correct.
All right. Now, by the way, am I correct that it is a violation of Louisiana State Trooper policy and procedures to tape record fellow troopers without authority from the superintendent?
I have no idea of that. I'm not sure.
You don't know that?
I don't know.
Okay. Now, let's talk about Kevin Reeves, because that's what we're here for.
Mhm.
What evidence do you have? Subpoena was issued that we're contesting. Kevin Reeves. The first thing says, what facts are to be proved by this witness? Number one, Mr. Cavalier did not violate policy. All right? What policy are you referring to, and what evidence does Kevin Reeves have of your violation or non-violation of that policy?
I'm unclear of what you asked.
Yeah, and if I can
I'm
lodge an
reading.
objection, are we relitigating the whole issue that my client requested a subpoena? This body issued the subpoena. Mr. Reeves has been found in contempt of not honoring the subpoena, or is this something new? Because-
There's also a request before this body to withdraw the subpoena. And it's
I
relevant- That
understand.
question is relevant to that issue.
Can you ask the question again?
Evidence do you have? You wrote down that one of the things you want Kevin Reeves to give evidence about, Mr. Cavalier did not violate policy. So we start with, what policy are you referring to?
Familiar with what you're reading from or what you're referencing?
Okay.
You mind if I look at that?
No, I don't mind if you look at it. Circle parts. Hold on to it and we'll let you read it as I ask the questions. Now you see number one, the first sentence.
Hold on, son. Give me a second.
Read the first sentence out loud, please.
Okay, so this is what I referenced a minute ago that
Pardon me. I just ask you to read the first sentence out loud.
Just read the first sentence of the description of the subpoena.
Mr. Cavalier did not violate policy, the discipline of Mr.
Hold
Just,
on.
just the first sentence.
We're gonna do this real carefully, sir. Unless I'm prevented from doing it. What policy are you talking about?
This should be in reference to secondary employment. If you're asking me, any policy.
Okay,
Mhm.
what evidence does Mr. Reeves have to give that you did or did not violate any policy? Either way. What evidence does he have?
Well, my position is, and I think you will learn from this paperwork, is that in the recordings of the legislative hearings, that Mr. Reeves set in motion the investigation into the leak, which is myself.
Is there a policy in the state police that permits state troopers to leak information of ongoing investigations to the news media? Is that permitted?
Not familiar with any policy that permits anyone to leak, but I at the time I was an officer, I was a trooper. And if I think a crime is being committed, then I'm obligated to report that crime.
And you reported it to Channel 2?
I reported it to a state representative. I reported to individuals within my chain of command prior to speaking to any media outlet.
All right, and were any of those individuals? I'm not on your case, Mr. Cavalier.
No,
I'm
no
on
problem.
One little thing.
No problem at all.
Were any of those individuals, isn't it true, sir? None of those individuals were Colonel Kevin Reeves. Can't we just agree to that?
No, we cannot agree to that because Toussaint Louverture, which was myself, through those emails, which Mr. Reeves received, I addressed those same sentiments through those emails and also through the Black Louisiana State Trooper titled email as well. So I cannot agree with you on that.
All right. Let me try to see if I can articulate this, Mr. Cavalier.
Okay.
The question is whether Kevin Reeves should be a witness in your case. What does he, Kevin Reeves, have to add to your case? Whether your case is good or bad, it's not my issue. It's about Kevin. I'm here on Colonel Kevin Reeves. Now,
And to the extent he's
What-
asking for a legal conclusion, I'm happy to make those arguments as I have in my briefs. But I would just like to note my objection under 701 that he's asking for a legal opinion of this lay witness.
The quorum in this proceeding is that we let people finish talking before we interrupt what they have to say. I'm saying that to both of you.
Yes, sir.
So please let him finish. Then if you want to make an objection, we'll hear your objection.
Yes, sir.
Cavalier, back to Kevin Reeves. What we're trying to find out is, he's here and he's sitting where you are. What in the world do you expect him to be able to tell this group that is firsthand information of his own. That's what we're really trying to do, see? So we start off, you issued a subpoena to him, and your first sentence was the reason for the subpoena, that you did not violate policy. Now, you've answered that question and the way you answer it. And I haven't heard you say the word Kevin Reeves had anything to do with it, but read the second sentence.
Raise questions, not arguments.
No, I said,
We're
read the
we're following what the testimony. is.
read the
Just
second
ask the
sentence, please.
The discipline of Mr. Cavalier was not in good faith and arbitrarily capricious.
All right, now, did you go to New Orleans? Pardon me. What discipline are you talking about?
This is the secondary employment discipline we're here for today.
Secondary employment, you need to help me. Is secondary employment discipline writing the book? And then talking to the news media, those kind of things. Is that what that is?
No, just not talking to the news media, writing a book.
Okay, all right. Again, prior to October 31st, 20, have you a shred of evidence that Kevin Reeves ever knew you wrote a book?
I'm not sure if he knew I wrote a book, to answer your question directly. But as I said before, while Mr. Reeves was had the position of colonel, he set in motion all of these things that I believe led to all the investigations into me and my disciplinary actions taken against me as well.
What evidence do you have that Kevin Reeves set in motion anything at all of any kind that relates to the second sentence you just read us about writing a book? Kevin Reeves now. Tell me.
Sound like I'm repeating myself over and over again. But as I just,
Let me try
Ron,
it
can
different.
he please?
Go
answer
ahead,
the
Mr.
question? I
Cavalier,
know he's-
keep talking.
He had-
I'm quiet. Keep talking.
He has been asked it several times, but I think he's trying to answer it again.
Keep talking.
I feel like he's asking a different question, but you're given the same answer to each of the questions. So you're allowed to keep asking the different questions.
Thank you, Ms. Boone.
I would overrule the objection and ask you to answer the specific question, whether it's the same answer or not, but know that you're being asked a different question. Need it
Change any
repeated?
Answer you have?
I don't want to change anything. Would you like to repeat your question?
No, I'll ask you another one. I want you to tell me, sir, with specificity, dates if possible, reasonably time frame if impossible, places, meetings, people present, documents, any evidence you have that Kevin Reeves knew you had written a book prior to his retirement.
As I said before, I don't know if he knew I wrote a book or not. I don't know that. I don't have that knowledge.
Okay. Would you read the third sentence?
Yes, sir. Mr. Cavalier was disciplined in retaliation for his protected speech.
Okay. Did Kevin Reeves discipline you for your protected speech?
No, he did not.
Okay. Next one, please.
Mr. Cavalier was disciplined in violation of his due process rights and civil service rules.
Okay. Did Kevin Reeves discipline you in violation of your due process rights and civil service rules as it relates to the issue before this committee, secondary employment?
No, he did not.
Next one.
Mr. Cavalier was not afforded prior notice and a reasonable opportunity to respond prior to imposition of disciplines.
All right. Are you referring to secondary employment? What this issue is about?
Correct.
And we've established that Kevin Reeves had nothing to do with that.
No, we haven't established that he had nothing to do with that. I believe he set in motion, as I said before, I believe he set in motion the things that led to all of these investigations into me.
All right. And that, if I appreciate that story you tell, is based on the fact that you think there was an effort according to Barnum, Oliphant, and White, at staff meetings prior to his retirement to determine if there was a leak in the state police and how to handle the evidence that might relate to that leak. Is that right?
That's correct. And also the fact that Mr. Reeves acknowledged the fact that he received this letter from me entitled Black Louisiana State Troopers, in addition to receiving two St. Louis Overture emails prior to retiring.
Okay. Now, I know that you've referred to it earlier multiple times, very carefully studied the committee hearings and the testimony of the different folks. So tell us where in any of the testimony by Mr. Oliphant, Mr. White, or Mr. Barnum, given to the committee, the name Paul Cavalier, Toussaint Louverture, Elijah Steele is ever uttered.
I can't recall that right off the top of my head, but I mean, if you know, I'm allowed to go back and review the videos again, I can come back with that answer. But off the top of my head, I'm not. It's a lot of video. It's a lot of hearings and meetings that went on.
Just not simplistically, sir, as to your appeal of your punishment here in front of this committee of the, is it 200 hours?
200 hours is correct.
Your idea that Kevin Reeves is a witness is based on your theory that he set in motion events that eventually led to your being suspended. And that motion he set in those events he set in motion was staff meetings about how to handle the evidence that was being leaked to the media. Is that right?
That's right. That's correct.
Okay. So when Davis takes over November 1st, you are at that time in no trouble at all with the state police. Correct?
Is that a question? I don't know if I was under investigation. I don't know if I was delivered a letter or nothing at that time. So to answer your question, no, to my knowledge, no.
And according to the documents given to me, the actual opening of the investigation of you, or that led to being you, but the opening of the investigation as to who is the leaker, et cetera, begins in June of 2021. Does that sound right to you?
Are you referring to the 200-hour suspension? Yes, 2021.
All right. And so Mr. Reeves has been gone then however long it is from November to June. Right?
Correct.
I have any more questions?
Can I ask some questions? The September 11th, 2020 letter that's addressed to Governor Edwards and Colonel Reeves, who helped you put that letter together?
Two names off the top of my head. I spoke with Draper Crane about this letter. I spoke with Kevin Leachman about this letter. And a number of Black troopers within state police I spoke with about this letter. And the sentiments in this letter, as I was telling the council here, that I've spoken with the majority of Black troopers within state police, and we've talked about these same things over and over again. But to answer your question specifically, the names I could remember right now off the top of my head are Kevin Leachman and Draper Crane.
Draper Crane was in your chain of command?
That's correct,
And
Lieutenant.
am I correct, the state police has a paramilitaristic chain of command policy, is that right?
That's correct.
And in layman's terms, that means if you want to report something up the chain, you have to go through first your sergeant, is that right?
That's correct.
Then your sergeant has to give you permission to go to your lieutenant, is that correct?
That's correct.
Lieutenant has to give you permission to go to your captain, is that right?
That's correct.
And up to the major, lieutenant colonel, and colonel, is that right?
That's correct.
And when you were discussing putting together your September 11th, 2020 letter to Mr. Reeves and to the governor, Mr. Crane was your lieutenant.
Lieutenant at the time. That's correct.
And did Mr. Crane give you permission to discuss what you contended was the problem with your captain?
Mr. Crane agreed that these were good points to make within this letter.
And before putting together the September 11th, 2020 letter, who did you discuss the Ronald Green and the racism issues with in your chain of command, sir?
What date did you give again?
Before you started putting together this letter, did you discuss with your chain of command the concerns you had about Ronald Green's killing and the concerns you had about racism within the state police?
That's correct.
Who in your chain of command did you talk to? with
I
that?
talked to my sergeant, David Floss. I talked to my lieutenant, Draper Crane, pretty much with anyone with an ear that would listen to me. But those people were in my chain of command. Those names who were in my chain of command at the time, I spoke to them. And the Troopers Assistance Program, I spoke to those guys as well.
And let me ask you a question, sir. With respect to your defense to this charge that you were improperly given a 200-hour suspension for writing a book, is part of your defense the fact that you believe that the action taken was not in good faith and it was in fact retaliatory?
Yes,
And is it your contention that the retaliation started under the watch of Kevin Reeves and continued all the way through when you received the discipline?
yes. And as I said before, I believe that Mr. Reeves was the reason, the person who set it all in motion initially to find the leaks, and ended up being retaliatory when they find out that, I was the leak, and, they were trying to find things to discipline me for. So it all came together, came at me at once, all the disciplinary investigations and discipline.
In your recording of Mr. Van Buren was on command staff under Mr. Reeves and Colonel Davis. Is that right?
I believe he was a major under Mr. Reeves and a colonel under Davis.
He got promoted?
Got promoted.
In your recording of Mr. Van Buren, does he reference the fact that you were identified as some sort of whistleblower?
He referenced the fact that I was speaking up, and speaking for other people. And Colonel Davis referenced that as well in our meeting.
And sir, in your conversation with Mr. Van Buren that's reflected on the recording, did Mr. Van Buren also tell you needed to find another job outside of state police?
Mr. Van Buren on one of the record.
Have an objection?
Please. Two things. Is there transcripts of these tape recordings that I don't have?
No.
All right. Number two, my objection is that when we're discussing other people like Mr. Van Buren, I'd ask that a foundation be laid as to when these events occur.
Paul, I can lay the foundation that your discussion that you recorded with Mr. Van Buren occurred around the time of June of 2021.
That's correct.
And that was before the imposition of the disciplinary action.
That's correct.
Did Mr. Van Buren tell you that the reason you were being disciplined is because you are a whistleblower?
Mr. Van Buren did hint to that sentiment, and also followed up with saying that I should take, he suggested that I take FMLA because it would protect my job. And at that time I started wondering, what did I need to protect my job from? Also, during that conversation, he explained to me that employees who usually, fall into the position that I was in as far as speaking up and, disagreeing with the department in so many words, end up doing one or two things, leaving the department or being terminated. And, from that moment forward, I just, my mind went further deep off into, protection phase of protecting my job, just as he suggested.
You mentioned that you talked to Draper Crane about several items. One of the things that we produced today are text messages between you and Mr. Crane, and they start, at least the date is June 3rd, 2021. Approach?
Yes.
these text messages with your then Lieutenant Draper Crane in your chain of command, does he reference the fact that he knows full well you're writing that book, sir?
Yes, that's correct.
And he even references the fact that he was aware that the Fusion Services, which was under then not yet Colonel Lamar Davis, was about to discuss or report or do something about your book?
Yes, that's correct. That the Fusion Center put out a memo in reference to my book. That's correct.
On the second page of the text message, do you see that portion where Lieutenant Crane says to you, "I know, but they should have been obligated to get help for you, and they denied you to get the spot"? That was about what you were complaining about to begin with. You see that?
I see that.
And sir, is it your contention that that is evidence that part of the reason you were disciplined was retaliation, which started back under Colonel Reeves?
Yes.
Additionally, he talks about in this thing, it says, "Oh yeah, and I done lost all my money back." That's him.
That's him.
And then he says, "Really telling people not to talk to you is about the worst thing they can do with that on record and with that complaint." He was referring to the original complaint from 2020. Is that your understanding?
That's correct.
And it says they probably didn't know that was in place when the word passed not to talk to you. Sir, would you mind telling me what was going on? Was state police, were your fellow troopers stopping talking to you anymore?
Yes. Draper was the one. Draper and Greg Handy and a few other guys were telling me that word was going around state police that no one should talk to me. They should keep their distance from me for whatever reason. And that is what this conversation is about.
In addition to this text exchange, you do have other text exchanges with the number of troopers. Is that right?
That's correct.
And all of that information has been turned over in connection with the federal civil rights proceeding to state police, right?
That's correct.
Understood. Now, in your recordings with others, you said Mr. Pinchon, Mr. Sams, Mr. Ducote, and Mr. Journey. Is there any reference in those recordings to your recollection where they talk about administration coming after you?
In a recording with Journey, Trooper Journey, he said,
And we always want a date.
that was the date I gave earlier, June 4th, 2021. Now I could be off because Pishon and Journey called within days of each other. So one was June 4th and one was June 8th, 2021. So I could be mixing those two up. But to answer your question, Trooper Journey called and said that, hey, just keep your mouth closed. But lay low, everything's gonna be all right, and joked that I shouldn't be writing a book.
That was before you were ever given a pre-disciplinary notice sometime in October.
That was before that.
Okay. And you mentioned that you talked to Mr. Pishon. You recorded that too?
That's correct.
And that was either on the 5th or the 8th of June?
That was either the 4th or the 8th of June, 2021.
Understood. And is there any reference to administration coming after you in the recording with Mr. Pishon?
I don't remember specifically. I have to go back and listen to that recording again, but I know it was noteworthy to me. So I saved it and documented it. But it was to the effect of laying low, and Mr. Journey was saying that the word was coming directly from the administrative staff, and I would like to know who. The administrative staff, that I should keep my mouth closed.
Sir, with respect to command staff, can you tell this tribunal whether or not the command staff under Mr. Reeves changed appreciably between his administration and that of Colonel Davis? In other words, were there some folks that were there when you sent these letters in and Edmund Jordan delivered them for you that were still there when they came after you in 2021?
What's the relevance as to the Reeves issue? That's my objection.
My response, if I may briefly, is I think my client has testified that part of why he thinks Mr. Reeves's testimony is relevant to these proceedings and should be allowed in these proceedings is because it was set in motion under his watch.
Ms. Pratt, can you limit your questioning in the testimony to finding out and asking questions about what evidence was discovered during Mr. Reeves' administration that, as your client referred to, set things in motion that
Sure.
resulted in discipline?
And I really don't want to reinvent the wheel. I apologize. But as I understand it, sir, let me back up and ask it this way. Under Mr. Reeves' tenure, which he ended within days after your first Toussaint Louverture email, can you tell me whether or not you had discussions with anyone in your chain of command about Mr. Reeves' administration coming after you?
I had discussions with, like I said, Draper Crane, who was in my chain of command, and Kevin Leachman, who was in a temporary chain of command as it relates to me working at the convention center during the COVID detail. I was talking to them about the investigations and the Ronald Green investigation, and also they knew my issues with state police, and I kept them abreast of, and it's in the text messages as well to answer your question about what was going on with me and what state police was doing and not doing with me.
In your Toussaint Louverture email dated October 16th, which was days before Colonel Reeves decided to retire, there is a reference on page 2 to the killing of Ronald Green. Is that correct? In the middle of the page, it says, let's fast forward to former Hollingsworth. In his own words, you see that paragraph, quote,
Yes,
beating the ever living shit out of him, end quote.
yes,
You got that quote from Hollingsworth from the actual body cam stuff.
that's correct.
And then you said by him, he meant Ronald Green, black man.
Correct.
Part of your initial complaint to Mr. Reeves, or at least this email that was sent to him, quoted directly from the Ronald Green audio. Is that right?
That's correct.
Then you go on to reference the Governor Edwards. Then you go on to reference J.D. Oliphant, Chavez Cameron, and others. Is that right?
That's correct.
And there was a second email, was there not, delivered by you through Toussaint Louverture, October 29th, the day before he left his job. Is that right?
That's correct.
On page 3, at the bottom of the page, you wrote, it is clear that Kevin Reeves, his command staff, and every person who viewed that murder on video but did not take action is complicit in the cover-up of Ronald Green's murder. Is that right?
That's correct.
Do you have any reason to believe that Mr. Reeves did not in fact receive the emails that you sent out?
No, I have no reason to believe it. They did not receive it.
And you referenced the testimony before the legislature. Is that right?
I did.
You talked about the second time the legislature, but you also listened to Mr. Reeves's own testimony before the legislature, which was at least a month ahead of time. Is that right?
I was there in person.
And you were there with Ronald Green's mother?
I believe she was there.
Yes, sir. Now, in the first set of testimony, who testified on that day?
I want to say Oliphant testified that day. I'm not sure. I'm not sure.
In the second day testimony, there was testimony by Mr. Barham. Do you remember that?
Okay, yes.
Where he testified that there was a directive from Mr. Reeves to find the leaker.
Yes, that's correct.
And sir, you understood that you were the leaker. You're
That's-
quoting from the video, from the audio, right?
That's correct.
Understood. And so would it be fair to say that Mr. Reeves set in motion the investigation of you?
100%, I believe he set in motion the investigation which led to all of these other things we're talking about.
And then we fast forward to April, the recordings that we've given to this body, where folks in your command staff are telling you that this is because you opened your mouth, right?
Yes,
The directives as it related to you, the investigation of you, you understood that was initiated from the command staff at State Police.
that's correct.
And sir, was it your understanding that those directives were initiated in 2020 when you started putting stuff in writing?
That's correct.
Even before you put stuff in writing, you indicated you went up your chain of command and tried to get something done about the killing of Ronald Green. Is that right?
I went up my chain of command, and as I said before, several chain of commands. On up until waited till Lamar Davis took office, and also went in there and spoke with him as well. Spoke to Colonel Van Buren several times, and also a few other people in other chains of commands as well about these issues.
When did you start trying to raise the issue of Ronald Green's killing not being justified?
Around March of 2020, when I learned of the Ronald Green incident, I was at the convention center in New Orleans for the COVID detail.
And do you have any reason to suspect that the folks in your chain of command that you started complaining about the killing of Ronald Green did not pass that information up the chain of command?
Speculation.
No.
Objection.
Sustain.
No, I don't have any
Wait,
reasons.
hold on, you can't
I'm
answer that.
sorry.
They don't want you to answer
You
that.
can-
So, sir, with respect to the Ronald Green situation, between March of 2020 and when you put your concerns in writing to Mr. Reeves directly in September 11th, 2020, would you tell this body how many times you attempted to get the killing of Ronald Green addressed by the Louisiana State Police?
Well over five times with different people, different groups of chains of command, sergeant, lieutenant, major, lieutenant colonel, colonel,
Which colonel?
Colonel Lamar Davis, and also at the time, Colonel Reeves through my letter titled Black Louisiana State Troopers, and through Toussaint Lou Overture emails as well.
In your request for the subpoena for Mr. Reeves, you referenced that you believe the disciplinary action taken against you was not in good faith. Is that right?
Which said,
What
repeat the
Mr.
question.
Oglesby had you read, he had you read one sentence at a time?
Yes, correct.
And can you explain to this body why you think the disciplinary action taken against you was not in good faith?
I don't believe it's in good faith because of what I explained to Mr. Oglesby. It's because of the fact that they were trying to, the department was under Mr. Reeves' direction, search for a leak. Now, reading these emails and all the information that I was putting out, I don't think they entertain the fact that if this information is true or not. Is there in fact a cover up? Was a crime or policy violations committed? Is he reporting things that are factual about the department, about individuals within the department and outside? I think it was all in retaliation of me reporting those things instead of, legitly coming after me for something.
Question, in those legislative hearings, the second round, I think the commission asked me to identify some portions of it.
Mhm.
Can you tell me the testimony of Mr. Barham, when he talked about the weekly meetings he had with Mr. Reeves to discuss the leaker? Do you recall Mr. Barham being asked at this same time, was there any investigation into the killing of Ronald Green? And his answer, I believe, was no, they were looking for the leak. You remember that?
I don't remember specifically the words he used specifically, but I remember them asking those questions, and him saying that they were looking for the leaks And they follow up with the question of who else was being investigated, or if there was investigation into Ronald Green. I think his response was on a federal level, it was, but not state police.
That's all I have, sir, but they might have some follow-up for you.
Very few, if any.
Sorry, Mr. Owens, we were gonna stop at this point. You want to,
Examination process and then.
Yeah. so do you want to have argument now on the motions to quash in general? And I mean, I think that it's been part of this, but I think if you want to have oral argument, we can begin with the motion to quash or recall the subpoena.
Sure. I'll be happy to do that. And that really, I can do it quickly. The last time we were here, gentlemen, I will apologize for
can
not
step down.
fully.
Oh, yeah.
The last time we were here, I wasn't as clear as perhaps I should have been, nor as educated as I should have, about the problem with the initial subpoena to which we had asked that you recall it and certainly not hold us in contempt. I go back to something that the lawyers on this committee and all of you know. A request for subpoena to a witness by a lawyer comes with the good faith indicia of reliability that there is evidence that witness has that is relevant and important to the cause in the case. My capacity as a lawyer to just ask for a subpoena does not carry with it irresponsibility. Now, we've had a chance to study what is Kevin Reeves' actual role in this? What facts are there about Kevin Reeves? Not Mr. Cavalier's entire case, but as it relates to Kevin Reeves. It is clear that first, the reasons he gave for the subpoena, according to him, he largely retracts now. The Reeves didn't have anything to do with these things. It is clear that Reeves had nothing to do with the ultimate discipline that's before you to decide at some point in the future. It is clear that no one, even today, with all of these different tapes and documents and emails and everything else, no one says Kevin Reeves knew who Carl Cavalier was. No one says Kevin Reeves asked that the leaker be punished. The testimony you have from the gentleman who discussed the investigation into the leaks, you've read it, is clear. The issue was, we have this evidence of wrongdoing by Chris Hollingsworth. The district attorney in Monroe has this case and is reviewing what action to take about it. We're not allowed to, nor should we have evidence that we've turned over to the prosecuting authorities created by the law enforcement authorities, put out into the public. So we need to lock down that evidence because the nature of the way we keep it electronically now makes it available to different individuals. We don't know whom, but it makes it available. So Barnum says Barnum, not Kevin Reeves, decides on his own that he thinks he needs to put more security around these various evidence, which I think are videos and other things. No one is discussing retaliation. No one is discussing an investigation of the leaker. No one is saying the word, name, or likeness of Carl Cavalier, Elijah Steele, or Toussaint Louverture. Sense tells you that if I have something important to say, And I expect the colonel of the state police to pay any attention to what I have to say. And I'm a trooper. I need to be talking to him, standing up like a man, raising my hand. The last thing I need to be is an anonymous person who may be just some nut. To suggest that Kevin Reeves is going to study these Toussaint Louverture, these two emails, and then somehow that is going to cause him. I mean, look at the leap they're asking you to make. That somehow he figures out that he's going to even read this anonymous email. There's only one during his watch. And he's going to later decide when he hears that there's a leak that they need to avoid leaks, which is exactly what they're supposed to do. That's their job. And somehow that leads to him having evidence of whatever Colonel Davis determined to do later with Mr. Cavalier. I mean, that's what I'm only here on asking you to recall the Kevin Reeves subpoena and to by necessarily reconsider the motion for contempt, because Kevin Reeves doesn't have anything to say. Whether what Colonel Davis did was right or wrong, justified, unjustified, that's none of his business, none of his right. Opinions are not of your interest, it's facts. Nobody's yet given me a fact, and you've listened carefully. Ms. Kraft has had multiple times to write whatever she wanted to write. Nobody's given us a fact. Kevin Reeves did this. Kevin Reeves said this. Kevin Reeves ordered this. No one. Because this wasn't something that it was in his command chain when it happened, and beforehand, he didn't have anything to do with Carl Cavalier. As Cavalier admits, never met him, except when he got an award. So, I'm asking you simply to relieve Kevin Reeves of the obligation of coming back here when he has nothing to offer. Your rules outline a procedure where you're supposed to put down the reasons for the witness to come. And Ms. Kraft, I presume, wrote those reasons. Now we've explored them. We didn't do that the last time. We now know that those are wrong as it relates to Kevin Reeves. Even if, I don't concede this for a second, but even if, in the wildest imagination of the complainant, Kevin Reeves put in motion by asking that the leaker, that they find out about the leaks, something that eventually led to Carl Cavalier being disciplined. Kevin Reeves is not the hand that does the discipline, the decision maker, nor knowledgeable about what all was decided or learned as to why to have any discipline of Mr. Cavalier at all. Nothing has anything to do with Kevin Reeves. So I'm just asking you, gentlemen, please, Colonel Reeves is a citizen of the state. He's retired. He recognizes his obligations and responsibilities to you folks and to all the state troopers who he strongly supports. He has come in good faith. He's come here in good faith. He's come to the legislature in good faith. Another thing that came up that may have influenced you, I don't know. I mean, I'm just, if I'm off on a tangent, I apologize, but I have to cover things in case they matter. When we came here the last time, Ms. Kraft made a point that she had seen Kevin Reeves held in contempt by the legislative committee on Ronald Reagan for not producing certain documents. I don't know if that had played a role in your judgment or not, but if it did, he is not in contempt of the legislature. That was all recalled. The documents were recognized as his private information, and they determined that they would take them and place them under seal Had that issue ever, had anyone ever offered that, to put the documents under seal, that had been done a long time ago, and there would have never been any issue. But previously, they were talking about wanting them to be public record, and they had things in them that were national security. They had things in them that were security in Louisiana and methodology of state police processes, and they had things in them about people that were their private business. The information about Mr. Green had been disclosed and taken out of the documents long before. But that's not, in any event, that's not an active deal. You know, I don't want that, if that influenced you, I hope that the fact that it doesn't exist will likewise influence. There's nothing for Mr. Reeves or I to say or do. It's going to make us know things that happen after we're not available. On October 30th, the state police procedures, which you know, when he walks out, his access to the computer, his access to the emails, his access to all the different internal information, internal affairs decisions, investigations, all of it is canceled. There's no evidence, because there's no event, that after he leaves, he does anything at all in regard to the issues of Mr. Cavalier or anyone in the state police. So I really respectfully request that you reconsider your prior judgment, that you recall the current subpoena for Mr. Reed, and that you just let us go on about our life. I also make one point. Our time, it's all limited. The plaintiff, if you want, the person wishing to win the case, to get you to reverse the decision, shouldn't want Kevin Reeves as a witness, because it's a waste of time and he doesn't provide anything. If Ms. Kraft would simply say, you know, reconsideration, I've talked to my client. It's true, Kevin Reeves doesn't have anything to offer. There's not a thing I can tell y'all that he has to offer. We'll have gone. Alternatively, gentlemen, if you're going to ask us to come back, I would ask you to rule that Ms. Kraft or Mr. Cavalier have to put in writing real facts that they believe are in contest that Kevin Reeves has evidence of, so that he can be prepared to come, and so that Mr. Hanneman can make a good faith judgment as to whether the subpoena should even be issued. Not generalized statements that are repudiated by the complaining witness. Thank you. Now, if you have any questions, I'm certainly happy to try to answer.
Yes, sir. The Louisiana Supreme Court in 2003 in Moore versus Ware made it very clear that in assessing whether or not a disciplinary action is substantiated, good faith does not occur if the appointing authority acted arbitrarily or capriciously or as a result of prejudice or political expediency. Arbitrary or capricious means the lack of rational basis for the action taken. The First Circuit, in the case of Moore, in-Ray Department of Public Safety and Corrections versus Thornton, affirmed a referee's granting of a civil servant's employee on the basis that there existed reasons for discipline other than that which was asserted in the disciplinary letter. It's kind of a fancy way of saying, as Mr. Cavalier said, there is a lack of good faith in the imposition of discipline in this case. And frankly, I ask you to consider the basis for the appeal submitted by Mr. Cavalier in proper person, without me, without a lawyer, without anybody. But one of the first things that he said to this body in filing his appeal was that he believed the disciplinary action was being inflicted upon him. He says this unprofessional influence includes the Ronald Green case. In the supplemental amending and restated appeal, part of his appeal was Mr. Cavalier shows that his prior discipline, 200-hour suspension, was because he spoke out against police brutality and racism within the ranks of state police. Months later, he was disciplined and suspended by LSP. He goes through and details what it was he meant by that, just like he did in the letters. I submit to you, as Mr. Cavalier told you, and by the way, I find it strange that the only person who has come and testified before you is Mr. Cavalier, who is out of a job. He didn't have some kind of retirement. He doesn't have any of that. He didn't have a job. He drives long haul trucks. But he's the only one who came up here and responded to the subpoena issued to him by this body and sat up there and answered all the questions he was asked. What Mr. Reeves is suggesting to you is now you upend your procedure. So now every time somebody gets a subpoena issued to him, we're going to have all these ancillary where they're going to make, in this case, Mr. Cavalier, who's been fired, come in here because somebody files late motions, gets held in contempt, and now they're coming back asking for a second chance, and they're making him testify. Well, he did. He did. Mr. Reeves has not. What my client told you and what he has consistently said throughout his appeal is that the imposition of the disciplinary action here, the book, the not getting secondary duty approval, was the product of essentially an action that begun on Mr. Reeves's watch. For some reason, I was ordered to go back through 4 hours of legislative testimony. I did. In addition to that, you are welcome to have my notes I took contemporaneously while I sat in there and listened to 4 officers testify before the legislature. And what they said was the only investigation they began as it relates to anything regarding Ronald Green, who, by the way, was killed on May 10th, 2019, was the investigation at Mr. Reeves' direction to find the leaker. I gave you the minutes and the seconds of that testimony from Mr. Barham that my staff and me spent another 4 hours listening to, so you would have that. You know, I submit to you, it's not just the person who pulls the trigger that's responsible, but it's also the person who loads the gun and sets it on the table and says, here it is. And that's what Mr. Cavalier has advocated in defense of this disciplinary action. And he's entitled to defend, not just because he says so, but because the Constitution gives him that right, as do your rules. I understand Mr. Unglesby's argument was these writings to the governor and to Mr. Reeves in September, my client's efforts that he told you he undertook through his chain of command to get this addressed, all of that stuff, Mr. Unglesby characterizes as the product of a nut. Let me ask you something. If he's such a nut, then how come only after he spoke out was there any effort to investigate the killing of a man in 2019? This nut is the one who started that. And this nut is the one who has paid the price. What we're asking is for full consideration of his defense as he set forth. Is it anything phantom? It is not as Mr. Unglesby described, oh, he put this stuff in writing, maybe Ms. Kraft did, irresponsible that she is, and requested the subpoena of Mr. Reeves. It was based on the knowledge that Mr. Cavalier has. It was based on the contents of the statements made to him by his commanding officers and fellow officers. It was based on the fact that he gave a letter to a legislator to deliver to the governor and to Mr. Reeves in September, which clearly calls into question racism within the department and the killing of Ronald Green. When they make statements like time is limited, Mr. Reeves shouldn't have to come back here and drive down. Well, let me ask you, how much time have we wasted with allowing Mr. Reeves to file late motions to quash after you've already held him in contempt and have all this stuff go on? while this man can't feed his kids except for long haul driving. I want you to know that to me, it seems very significant that people don't get a right to load a gun, set it on the table, and when somebody else pulls the trigger, that they get to say, "Pfft, not my responsibility." As part of his defense and as an asserted claim specifically in his original appeal and as supplemented and amended, that is an issue before you because he's entitled to defend himself. And we ask that he be allowed to do that. Mr. Reeves may not have a lot of testimony to give, but he certainly has some. And he certainly, my client certainly has the right to ask him to come talk about the investigation that started on his watch. The fair shake. I get it. He didn't want to have to drive back here. Guess what? My client certainly would like to have had his job maintained. Thank you.
Gentlemen, the question is simplistic.
Just 1 second. You're gonna entertain rebuttal?
If you don't want to, we don't have to. I mean, I was.
1 minute,
I'm sorry, sir, what?
1 minute.
Oh, I don't need it. The question is simplistic. What does Reeves have to say or give that's of consequence to this investigation? And the answer to that is nothing. Everyone that's been discussed as actually doing something is available as a witness. Everyone that's been discussed as talking to Carl Cavalier is available, I guess, as a witness. One person who Carl Cavalier never talks to, never in dialogues with, and who never does anything to Carl Cavalier at all, nothing, has nothing to do with whether he gets a 200-hour, a 5-hour, a no hour, or a firing, is the gentleman sitting next to me. So now maybe no one knew that before, but we now know today. And that's why the subpoena should be quashed, and that's why the contempt order should, independent of our good faith efforts to comply, should be withdrawn. Thank you.
Right. And I guess we're ready to move on to the next one.
Sure.
Do we need a break?
Or do you
Let's
need a
take
break
Let's
first?
take a 10-minute break. The next one is going to be that.
The next one will be Jason Turner.
Wait around till everybody's finished. It's all one deal.
Unfortunately, yes.
Yeah.
Okay. It's just a question.
It's my turn.
Go ahead and call the meeting back to order. Motion, are we on?
This is Jason Turner. Motion in limine by Jason Turner to establish areas of examination.
Ready?
Ms. Barnes, proceed.
Good morning, Mr. Chairman and members of the commission.
Go ahead and identify yourself first.
I'm Jim Boren. I'm an attorney in Baton Rouge, Louisiana, 830 Main Street, and I'm present with Jason Turner. We're ready to proceed.
Ms. Kraft.
Yes, sir. Jill Kraft on behalf of Mr. Cavalier, and we are likewise ready.
So it's my motion. My request, I believe, is a relatively simple request, and that is that that the commission determine the areas that Ms. Kraft believes are relevant areas to ask Mr. Turner about, and that the commission make a determination as to whether those matters are relevant to the to this case, which is understood at Mr. Cavalier's appeal and of his suspension for secondary employment, which is the book, and for conduct unbecoming. It may be that some of that issue can be resolved. I understood Ms. Kraft to say that pile of documents that she and Mr. Unglesby were talking about had matters that were relative to and perhaps dispositive of Mr. Turner's motion in limine. So I would ask that she also identify which of those documents pertain to Mr. Turner so that we might review them. I'm not saying, we do not suggest that Officer Turner does not have relevant testimony regarding the appeal of Mr. Cavalier. There are some things that he participated in. They're minimal in my view, but I can't say, I don't call him, he doesn't know anything, because he did have some email correspondence in regards to that passing basically information. So I can't argue in good faith that he has no information whatsoever. I did find it, I suppose, ironic is the best word, that the Louisiana State Police is accusing the Cavalier of using this proceeding to obtain discovery helpful to the EEOC and federal civil rights complaint, and that Ms. Kraft is arguing that the state police and vice versa, that both Mr. Cavalier and the Louisiana State Police are using this proceeding for the purposes of obtaining discovery relevant to two other matters, and to the extent that that's permissible. You know, I don't really have a dog in the fight. What I want to do is, when we appear in July pursuant to our subpoena, is we want to know, I want to have him prepared to answer questions. I want to know the areas that he's going to be asked about, the documents that he's going to be confronted with, and I want to prepare him so that his testimony is knowledgeable and educated and accurate. So I know that the objection to my motion in limine says that I'm trying to limit testimony. I didn't see that in my pleading. What I said is, I want her to Mr. Cavalier's counsel to identify the areas that that she believes are relevant as to Mr. Turner and the documents. And one other thing, at the last hearing, the counsel for Cavalier said that part of the problem was that there were a number of documents that she wanted Mr. Turner to identify or verify as his. And immediately after that hearing, I sent an email to their offices saying, what documents do you have that you want us to verify? Because we can shortcut all of that. My guess is that anything you have that has his name on it that he sent or received or is involved in, that he would identify. And I have not yet heard back from opposing counsel on the request to share those documents. So I'm asking the commission, simply put, to find out what it is they think Mr. Turner's areas of inquiry would be and what documents they want to present. I'm not trying to quash the subpoena. I'm not trying to avoid his appearance. I'm recognizing that he has, I think, limited and very small amount of knowledge, but I want to be prepared. I want him to be prepared for the hearing. I probably could go on for another 45 minutes if you would like.
Mr. Boren, I know you well enough to know that that's true, but I'm glad that you stopped. Y'all met with Ms. Feeney about these issues?
No. I didn't know there was an issue until today of not producing.
Well, I didn't know about the subpoena documents that were presented until today when I saw them. So I wasn't aware of that and her representation that there were things relevant to Mr. Turner's motion in limine. And I haven't called upon a referee to mediate my dispute, if any, with Ms. Kraft, because she simply hasn't said, yes, I'll give you the documents that I want you to identify or not.
Ms. Kraft?
I'm a little taken aback and sort of speechless, which is really extraordinary for me. I have never, honestly, seen the level of motions filed in a civil service proceeding that I'm seeing here. What I understand Mr. Turner wants in paragraph 2 is he wants there to be no questioning about anything surrounding the death of Ronald Green. Why is that? Why? I don't intend to turn this into a Ronald Green inquiry. I do not. But I darn sure know, to the extent my client contends, as he has throughout and is raised in this appeal, that his disciplinary action is secondary to retaliation. I think I'm entitled to ask, what did he report? And what was it? And why did that make everybody so edgy and angry and upset? And all running in here with 2 criminal attorneys saying, please don't ask my client any questions. Here is what I'd like to know. On the face of the letter, which we attached as Exhibit B to our opposition to this motion in limine, which, by the way, in all the time that I've appeared before this commission and the Civil Service Commission, I've never seen a motion in limine. Even in matters that I have in court, the notion of filing a motion in limine to tell me, the plaintiff's attorney, please give us the questions in advance so we can prepare, is not something I've ever really heard. It's not something that I think is even allowed under the Code of Civil Procedure. I believe it's 1469 relating to protective orders. But that's what they're asking you to do. In Exhibit B, which is dated October 13th, 2021, the state police letter to my client, Mr. Turner is referenced as having direct involvement in the investigation and discipline of Mr. Cavalier that we are here about on at least 7 separate occasions in the Internal Affairs Report and 6 occasions in the October 13th, 2021 disciplinary letter. Among the recordings, and certainly the information that I understand Mr. Turner possesses, is that there was a meeting that occurred on June 4th, 2021. The subject of the meeting was, as I understand it, how LSP, including Mr. Turner, could utilize the fact that my client authored a book to impose discipline on him because he wouldn't shut up. And that's it in a nutshell. With respect to support for that, because I'm sure you're going to want to ask me, there was, which is publicly available to you, text messages that were obtained by Channel 2. I don't even think from my client, from other folks who have started feeding information. It's between, I think, Colonel Davis and the governor, talking about my client giving an interview to Nakamoto, and they're going to look into it and they're going to figure out a way to deal with Mr. Cavalier. Come on. The reason that he has appealed this thing is because if you look at what's happened to my client from 2020, when he started opening his mouth and questioning, gee, why is this African-American man dead? And why are the state police telling his mother that it was a traffic accident? Look what happened to him. Not just him. How about Mr. Paxton, who came before you at the last meeting? He had discipline, which ultimately I think got recalled or something like that. I want you to ask yourselves, why is it these two guys? Why is it that they're here? Why is it that they were disciplined? And Bupkis anywhere else? What is a systematic effort to try to get you to buy into their narrative that he's not allowed to ask questions, or that I should be required to give them those in advance. This is not a take-home examination. My client didn't get his questions in advance. He sat over there and told you what he thought and what he knew. But so far, all these high-ranking people in state police have found it incumbent upon them to come in here with criminal attorneys and say, please don't ask us anything. And you, commission members, need to agree to that and limit this proceeding. My client, as I indicated in the last argument, has a constitutional right to defend against the disciplinary action that in this case took 200 hours. 200 hours. My client went back to work for one day, maybe one day, since April of 2021. They put him on forced leave, which is also an appeal that you have. After that, they put him on 200 hours of suspension. After that, they took his job. And here we are, a year later, over a year later. And all these people come in and they talk about, it's my time, wasting my time to come testify. Well, what about his? I ask you, when is it in the recollection of the commission that we've had all this ancillary business going on? I certainly can tell you in my experience with the commission, I never got this kind of luxury. Even when I complained about subpoenas being overly broad and brought up the issue, we certainly didn't have all these ancillary hearings where I'm bringing in and saying, bring this person and let them testify. Oh, no, I don't want to testify. I certainly don't want to be under oath. I certainly don't want to have an attorney questioning me about what I know or how we got from point A to point B. That just doesn't happen. The federal proceeding where they can raise those issues by coming in and saying, we wish to assert a Fifth Amendment privilege against self-incrimination. So therefore, we wish to invoke a doctrine from Heck versus Humphreys. That's not this. This is not a criminal proceeding where they get to come in and say, I wish to assert a Fifth Amendment privilege, and please don't let Joe Kraft ask me anything. I don't want to answer it. This is an administrative proceeding designed to ensure that my client was removed for cause and in good faith, and not in a manner that was arbitrary and capricious. In that regard, he identified specifically what he believes happened to him, and frankly, the evidence supports it. I'm sure you have not had an opportunity to listen to the recordings of the others. I ask that you do so. I do. The other thing that keeps being raised is this notion of, gee, we didn't know what documents she had. Well, how is that? Because in federal practice, we were required to make what are called initial disclosures under Federal Rule Civil Procedure 26, which means I got to give them all the stuff that I have. And I did months ago. So how come state police has decided not to share with their own? That's not on me. It's not my obligation to go out and say, gee, here's all the stuff I want to ask your client about. And so therefore, somehow here are the questions. What is that? How about if that's what you want to do, then you make them have to spit all their cross-examination questions that they're going to ask my client. Fair's fair. How about we just do it this way? You make all of us have to submit written questions and we just do it that way. The reason it doesn't work that way is because that's not how you get to the truth. That's not how you judge human reaction. And that restricts your ability to knowingly and intelligently question somebody. If, for example, they say the sky is blue today and you know it's black, don't you think you get to ask a follow-up question? Gee, have you been outside today? That's the give and take process of examination and cross-examination. I get it, it's not a court, but at least we have a modicum of semblance that this does function in the world of administrative procedure. In this particular circumstance, I ask you not to look beyond what appears to me to be fairly obvious. One of the other things we raised, although that's something you're going to have to decide, is they blew their deadline. On June 4th, 2021, they had a meeting at which Mr. Turner was present among command staff. On June 4th, 2021, they talked about using the fact my client had written a book to get him. That's what they did. That's what the evidence is going to show. When was he disciplined? Not until October. Under the rules of this commission, it's 60 days. 60 days. I get it that in August of 2021, the Peace Officer Bill of Rights was amended to make it 75 days. But I understood the position of this commission was that it's unconstitutional as it relates to us, and we follow our own rules. Well, your rule says 60 days. So ask yourself, why are we going through all this? Why is it they waited so long? Why is it they blew their own deadline? Why is it everybody's so focused on, please don't make me testify. Don't make me have to take an oath. Let's make Carl do it. Why is that? If this body is dedicated to the search of truth and whether or not this disciplinary action was undertaken in good faith, for cause and not arbitrary and capricious as demanded by the Supreme Court, then this business about, please tell us what you're going to ask us. Here's what I'm going to ask them. This is very simple. I'm going to ask them what happened leading up to my client getting a 200-hour suspension. That's what I'm going to ask them about, all of it. From when it started in 2020 and all the way through. That's what I want to know. And that's what this man put in his defense. And that's what this man put in his appeal. And that is the issue before the commission. I'm not here to waste your time. I'm not here to have sideshows. I'm not here to do any of that. I'm here to get this man his 200 hours back in this case. I'm here to get this man his job back in the termination case. And I'm here to get this man his forced leave back of 72, 80 hours, something crazy like that. That's what I'm here to do. Thank you.
Gather that the fact that I have defended people, innocent people accused of crime, is some issue that's significant to the plaintiff's counsel by referring to me as, why does he have to have a criminal lawyer here? I guess I don't understand that, particularly since my practice is more diverse than that. So I'm just going to say, we're not claiming the Fifth Amendment. We're not arguing anything about a criminal case. We're here to find out what it is that Mr. Turner is going to be asked about. I'm beginning to get some of that. For example, they say that he was present at a meeting on June the 4th in which a number of discussions happened. Well, A, he wasn't there. B, not a single human being will testify that Mr. Turner was present at that meeting. So, obviously that's a fair question. They can ask that question, but the answer is, I don't know where they're getting their information. I assume they make that allegation in good faith, that we have a witness who is going to place him at that critical meeting on June the 4th. They don't have a witness, in my opinion. But I just want to go back to really, what is the purpose of this motion? This motion, it was enhanced when the plaintiff's counsel this morning said, this big stack of documents that we have right here, I've got a bunch of documents in there that are relative to and may be dispositive of Mr. Turner's motion in limine. And so I'm saying, show me those. Or I'm asking the commission to say, give them to Mr. Turner's counsel. Second, I don't know why it is. I guess it's the theory is if you say something that's wrong enough times, there becomes some truth to it. There is no truth to the argument that Mr. Turner is saying, I don't want to come testify at this hearing. He's not saying that at all. he's coming to the hearing in July. He plans to testify at the hearing in July. And he plans to testify about matters that are relevant to the book and the conduct unbecoming appeal. So, I think what this commission has to determine, and you may not be able to determine it now, is whether all of this allegations that Mr. Turner was somehow involved in a conspiracy to get rid of Mr. Cavalier, and that's why he was really fired. I mean, I get that that's their point. But if there's documents to that effect that involve me, I think that we should be provided. The last thing. I never believed that I had the right to cross-examine Mr. Cavalier and to submit questions to Mr. Cavalier at his hearing in which my client is a witness. I'm gathering that that's what Ms. Kraft is suggesting, is that I should list the questions that I want to use on cross-examination of Mr. Cavalier. I do not need to cross-examine another person in my life to be satisfied with my legal career. I have plenty of experience doing that. I don't need any more. But I would like that to be clarified if I am allowed to or permitted to cross-examine Mr. Cavalier as a non-party, but only as a witness, then let me know. But I see, Mr. Chairman, you're shaking your head, and I was shaking my head in the same way, that I didn't think that that was something that I should even, I just wanted to address it and make sure I'm right. I don't have that right.
Don't ask.
Okay, all right. Can I have 1 second? I don't want to be in competition for the longest hearing on a motion. So I don't have anything else to say.
Any commissioners have any questions? Thank you.
I do, if it's asked, I have an extra copy of the documents. The only thing I don't have are the recordings, but I'm happy to email them if he wants them.
Thank you.
Mhm.
Do you want to hear argument on the contempt issue at this point? Mine is extremely brief.
Yeah, yes, go ahead and proceed with that.
Do you believe a lawyer when he says what he has to say is very brief? All right, I'm just saying.
But unfortunately, we have to hear you anyway. So
Yeah. So here's my view on that. The commission has found Mr. Turner in contempt. I think that, whether he showed up or not, that's been determined. He didn't, and you found him in contempt for that. The question is the punishment. And one aspect of punishment to me is how much damage did he do to the case by not appearing? And I think after you hear his testimony on July 28th, I think whatever the date is in July of the hearing, I believe that you will say, well, he didn't really have anything to add or say. And so the punishment that he received should be tempered by that. And so my suggestion is that you defer a determination of the punishment that he faces for contempt until after you hear his testimony in July, whatever that date is.
any response?
Briefly, it's not my province to decide the punishment. That is uniquely yours. But I will point out, as we did in our brief, Mr. Turner is specifically referenced as having direct involvement in the investigation and discipline of Mr. Cavalier with the 200 hours on 7 occasions in the internal affairs report and 6 separate occasions in the disciplinary letter. I don't necessarily agree with deferring, but frankly, that's directly at issue here. Mr. Turner is not an uninvolved third party who has nothing to do with the discipline of Mr. Cavalier. If that were the case, frankly, I'm not sure why there would have been at least 13 references to him in those 2 documents which are before you. Thank you.
We will next call LSP.
Thank you.
For all the parties involved, we're going to have an executive session after these arguments.
Okay.
We may issue some.
Good afternoon. My name is Tunde Animashaun. I'm stepping in from Glenn Holland, who is not here today, and I will do the very best to send our evidence to you. There are two motions that we file. One of them is, the first motion is to limit, our issue is production of documents. And then the other issue is the motion in limine that we file in the case.
Let's first talk about the production of documents. I understand there's been further communication between the parties relative to some.
We do have a telephone conference, I think May 27th, whereby Ms. Fina, Ms. Gail Holland, myself, and Ms. Kraft were on the telephone, whereby we were asked to give another search, which we did, and we submitted it to Ms. Kraft, and which we comply with at that time.
So this is what happened. Number one, I thought this issue was decided already, and you asked us to get together, which we did. What I did is submit to state police a further limitation of terms. Among those were Toussaint Louverture, which is some of the stuff I gave to Mr. Unglesby earlier, and in response to the subpoena, because I'm figuring that's the best play, go to the horse's mouth. And I anticipate he was going to ask for it, so I might as well do that. I also limited my search terms, and I think we limited the scope. I received the documents which you have in evidence from state police on May 27th. I additionally asked them to do the following, because they had indicated to you that they had received millions of documents. And I think, as I told you, at some point, I'd like to go through said millions of documents. I do understand, as of, I believe, last week, that state police issued an electronic preservation notification, finally, to everyone in state police to preserve any and all emails, text messages, documents, et cetera, relating to Carl Cavalier. Of course, that's well over 2 months after I think we asked for the original subpoena, but I do know that electronic preservation notice has been formalized. When a federal lawsuit is filed under the Federal Rules of Civil Procedure, that's supposed to happen immediately, which would have been last year. But nonetheless, that's in place. What I asked state police to agree to, and I believe that they did, is maintain the documents they had originally produced, which they told y'all was too much, too long for them to go through, et cetera, so that at some point I'm capable of going in and reviewing them myself. I don't know that they've taken any further steps to review those documents since they originally told us. But as long as they're segregated, if I can't get them here, then I guess I'll figure out some other way to get them at some point in time. But I certainly do not want my silence on that subject to in any way give credence to the notion that they are excused from A, producing, and B, maintaining the documents we originally requested. I understood that's what they said they've done. And I guess at some point we'll get around to it. Thank you.
Also, if I may, we have Derek Williams here, who is from the Office of OTS. He could tell you, what effort we take, in order to do those search, if that is okay.
Yeah.
Your name, sir?
Derek Williams. I'm with the Division of Administration under the Office of Technology Services.
You have an opportunity to review the search from Ms. Cobb.
I did.
What did you find? And can you tell the commission?
Sure. So we are not the data custodian, so we do not go through, I do not have the right to go through the content of those emails. We basically just perform the discovery for those emails as the Office of Technology Services runs the statewide email system. So we ran the request and presented that back. It was just under 7.2 gigabytes and about 12,000 individual messages, and we had some discussions about what that meant in terms of volume of data And so I think at one point you all asked me to give you kind of a representation of what that meant. And I told you that 7.2 gigabytes was, if you converted that over to unformatted text, that'd be about 3.5 million pages or so of unformatted text if you printed it.
How long will it take to print those millions of documents?
I couldn't say from a legal standpoint, that'd be a lot to go through, but yeah, it would be a ton of time. So I have no idea how long that would take to actually parse through that much data.
If we start those documents up, could you tell us how high that document would be?
We did have some discussion on that. It was, I did some quick calculations on it just to help visualize it. 3.5 million pages based on, it's about 2 kilobytes for a page of unformatted text. And using that, we could say, extrapolate that out to say that it was, it'd be taller than the Empire State Building, essentially is what that would come to once you parse that out based on the average number of words per page. And using 5.2 inches is the average size of thickness of a ream of copy paper and 500 pages per ream. So yeah, that's the visualization I think I had given you all when you asked me what that would look like.
So any question the committee may have?
I do. Mr. Williams, you indicated that you are not the data custodians of the information that I requested. Is that right?
Correct.
Who is?
State police.
So state police then are the people that would actually go through all of those documents and determine what, if anything, they were going to turn over? Is that how that works?
Correct. So I should say Department of Public Safety, I guess, is the custodian. We are the email service provider. So we pull those documents. They give us the search terms. And so those are the targeted search terms that we run and what mailboxes to run those on and in between what dates. And we turn those documents over to their legal. And after that, it's out of my hands and my group's hands.
You were able, were you not? I mean, I realize you're talking about a whole bunch of dead trees and paper. You were able, however, to take that electronic information and put it in some sort of form, right?
Yes.
Like what kind of form?
It was a PST file.
What's that?
So it is, if you've ever done an export from your Outlook, so Microsoft Outlook, you can save basically all your email out as what's called a PST file, which stands for personal storage. I forget what the T stands for, but yeah, it's basically just a file that you can then load into a viewer like Outlook to review.
Okay. So if I was looking at like what size that would be, it's certainly not the Empire State Building. It's like what, a little thing like this? Maybe 2 little things like that?
When you say the size of,
Yeah, like the thing. If I wanted you to give me the documents that had been cobbled together from my original search terms, you would give that to me on some sort of medium, right?
well, typically because they are an internal agency, we have a secure intranet. So we actually put those on a secured shared drive that only their legal department has access to. So there's actually no physical media exchange to prevent any security issues.
So can you tell me, has anyone affiliated with state police actually bothered to take the time to start going through the electronic documents?
I know that they got access to and confirmed that they had the copy, but I'm not part of the process whatsoever with the DPS legal team.
And I asked, did I not, for specific recipients of emails, is that right?
Yes.
And whose emails was I looking for?
Let's see, we have a list of them here if you want me to go through them.
Yes, sir.
So let's see, copies between Superintendent Lamar Davis, Lieutenant Colonel Jay Oliphant, Lieutenant Draper Crane, Trooper Leander Journy, excuse my pronunciations, Trooper Troy Pinchon, Captain Trione, Captain Salam El Amin, Major Jason Turner, Lieutenant Colonel Chavez Common, Lieutenant Colonel Kenny Van Buren and/or Kevin Rees, and Governor John Bell Edwards and/or any representatives and/or aides regarding in any manner the following terms: Carl Cavalier, Ronald Green, cover-up, excessive force, book business, undercover name, pseudonym, pseudoname, secondary employment, retaliation, assault, and/or battery.
Okay. And running those terms, for example, cover up. How many times did you see the word cover up appear in Mr. Reeves' email?
But we don't look at the emails. I don't see the content of any of the emails. We simply run the search and provide the results.
So you can't tell me, for example, how many times the term cover up as it relates to Mr. Cavalier appeared in any of those guys' emails, right?
I can't tell you anything about the context or it being related to your client at all. We don't look at any content or anything, which is, potentially one of the issues always that comes up with search terms is these terms are what we call ORD, which means any of these, this term or the next or the next or the next. So any one of these terms on its own will cause that email message that's being looked at to be pulled into the result set. So there is nothing, if these are not anded with something to give it context about this case, any of these terms on their own, like battery or assault, they do not have to have anything to do with the context of your case. If these are ordered like this, they will be part of the results set.
Okay.
But that being said, I have absolutely no way to know that.
Got it. So when did you get the request to run those search terms on those specific emails?
I believe there was an initial request on April 1st.
Of 2022.
Yes, and then I believe there was some follow-up questions about whether it was just from the from and to across all mailboxes or whether it was going to be limited to the mailboxes for these people. And I think we got that confirmation, some clarification back to my team on the 4th, and then that search was run that day.
So you were able to put all this stuff together in less than one day?
Yes, we have a very robust system for the entire state of Louisiana. So we absolutely have to build out to handle this kind of thing.
So that was April 4th. Today, by my math, is June 9th. So can you tell me what, if anything, has happened in over 2 months?
Once we put it on that result set out there, we have no visibility into it after that.
And you understood that was a subpoena that was issued to state police?
We actually didn't know. So the way that comes in is we have a standard request, a form that data custodians can submit, and they do not have to specify whether it's a subpoena or not. We simply got the request and turned it around as soon as possible.
Understood. Now, in that request, you don't see anywhere where I asked anybody to print it and kill trees. You just simply see where I made the request for the electronic information.
We actually don't see your request. They fill out a separate form. We don't know where that request came from. So.
And you're familiar with something called the native form of data, in other words, the manner in which it's maintained?
Yes.
Is that right?
Mhm.
And so what you turned over to state police on April 4th, 2022 was in its native form, is that correct?
Yes.
It was as it appeared.
Yes.
In other words, the emails Mr. Reeves sent, the emails he received with terms like Ronald Green and cover up and that kind of stuff. Yes,
Yes, those are pulled directly from the server.
understood. That's all I have, sir.
Any commissioners have questions? Yes, sir. Commissioner. You're not involved in this, Mr. Anderson. It sounds like I just ruled you not. Go ahead, Mr. Knapp. Commissioner Knapp.
I'm trying to understand when I print out emails, I get a trail and it may entail maybe one in, let's say, talk about a battery that occurred in it. And if I get one email, does it include all of the emails in that trail that may have been exchanged between individuals?
So if you did a reply, as you typically would, if you got an email that had the word battery in it, you said, I want to reply to this, and it includes that original email. Yes, that search would have both the original email in the result set as well as your reply, which includes that original email in it. So yes, all of those will be in there.
So there's a lot of duplication in that 7.2 gigabytes.
Yes, in the terms of there will be replicated content. There won't be exact duplicate emails in the terms of we won't pull the same email twice. But if your response is technically a different email, but it can contain the content from an original email, it absolutely will pull both of those into the result set if they both have a keyword that has been part of that search.
But both of them would need to have the keyword?
Correct.
before they get that response. Um, Some more questions I got.
Is there any follow-up?
Yes.
Based on the questions that were asked by one of the commissioners, you presented the witness, she crossed, and you have an opportunity to redirect the witness or ask any questions related to questions that we asked. Go ahead.
No follow-up, yeah.
Oh, okay.
That
Do you
may be
have any
excused.
questions based on the questions asked by Commissioner?
No, sir.
Mr. Chairman and the commissioners, I think good faith efforts to comply with the subpoena. And we did that also because we have some information as to what we need to produce when the modified request was made, which was promptly provided to Ms. Kraft. We believe that this request, there are 5 questions that was posed to us. We were able to answer 3 of those diligently and on time. The question number 4 and 5 was the one that we have an issue of. There are 5 issues that were presented to us, which we adequately presented answer to question 1, which we adequately respond to question 2, which we adequately respond to question 3. Question 4 and 5 is very broad, and some of those issues are not even germane to the issue that is before you here. One of the things that I find out is that there are 3 separate appeals. One deal with the 200 hours of suspension, one deal with the 60, the discipline, and also the termination. But all of this is not, these are separate. But what we find out is that all of this is in the same bowl, and that I believe makes it so burdensome. I believe also makes it so not relevant to what is before you. And the issue before the commission is the secondary employment and conduct unbecoming, which Mr.
Let me ask you a question before we move on to that next argument relative to the argument you just made.
Yes, sir.
Has the department made any suggestions to Ms. Kraft, counsel, or Mr. Cavalier as to ways that the department has requested that she narrow the scope of her request so that you can comply with it?
We did have a telephone conference.
Y'all had a meeting with her, but I'm talking about relative to the root. And based on the meeting, if I understood correctly, please, either one of you correct me if I'm wrong, y'all came up with a supplemental response that asked for certain things, but there was no agreement that that would put it into the subpoena. Is that correct?
That's correct.
Do you agree with that?
Well, I came into the meeting towards the end that the email did say that she still wants some more documents because I know I read the email.
So did not put an end to the request for the subpoena. So my question is, has the department in any way responded and said, look, we don't think some of this is relevant. You need to narrow this request?
That's the reason why we filed a motion to limit the subpoena.
Before you get before us and ask us to do that, the parties need to get together and try to work those things out. If you can't work it out, then you come to us, but don't ask us to do your work.
Man, I understand that. I've been practicing law for over 30 years. The issue came up when Ms. Kraft asked over here that we didn't supply, and then she asked for motion for quash. I understand that even in federal court, they don't get involved in this kind of situation. Party goes together. That is what the civilized people do. They come together, try to resolve the matter, and then if you can't resolve it, we go either before the magistrate or the judge. And I think that would be a good thing to do if we can be able to work together. But that did not take place in this situation.
And briefly respond. Mr. Knapp, to answer your question, I don't know a lot about technology. My kids probably do, but I sure don't. If state police had a suggestion for me of all those documents to take out what he called the replication, I'm happy to have that. I certainly don't want to have to read through on a computer screen all that stuff, but we just never got that. The thing that I've asked him to do, I did issue some additional terms for the purposes of these hearings because I know what I needed, at least in the immediate future, but I also had them agree to maintain the integrity of those documents. I'm with you. If there's something they can tell me, or Mr. Williams, who obviously knows way more about this stuff than me. I'm happy to do that. So we don't have all this replication. But at the end of the day, I'm asking because you already found these people in contempt. Here's what I'm asking. What the heck have they done since they originally segregated that information in April? What? And
What's the next item?
Yes.
I'm not trying to cut you off.
I understand. Yes, sir.
I
Understand.
We have the point. What was the next argument?
The next item is about the issue of contempt. And we wanted to say to you respectfully that we make good faith efforts to respond to the subpoena. Not only that, we do not have the labor, we do not have the power to be able to comply with that. It's not that we did it in bad faith or in a way to delay producing those documents. Efforts were made to produce those documents, and we don't have the manpower. There's a lot of confidential information, as Ms. Kraft said. There might be some issue that is still currently pending in federal court. We have to be able to separate that. We don't, and that's one of the reasons why we wanted it to limit those requests so that we're able to comply with it.
Anything else to submit on this?
There's a whole nother motion.
Yeah, there's.
I thought there, I'm sorry, I thought there was one more that they had filed.
Motion and limited to.
This one,
exclude it.
emotion in limine, and many of those issues that we filed before you has nothing to do with secondary employment or conduct unbecoming. And we want the commission to be able to look at our motion, to be able to see that those are not even relevant. And we cited in our memorandum, the relevancy of those EEOC claims has something to do with 200 hours of suspension. There's a whole lot of stuff in that that is not even relevant to the 200 hour suspension. And we would like an order to, in such a way that is limited to the 200 hours of suspension.
Tell me exactly what order you want. I'm trying to understand what order do you want us to issue?
First of all, they are not relevant.
What's not relevant?
Those items that we listed, there's a lot of.
Excuse me. I can't hear the witness testify.
There's pending a motion and limited to exclude witnesses. And there's also in the body of the memo in support, there's a request for exclusion of a bunch of documents as well.
That's correct.
So I'm just trying to get oriented on.
Let's take the document first.
That was the one thing that we were talking about not taking now.
I mean, insofar as documents are concerned, y'all gonna have some pre-trial conferences with our advisor. And those are things we're not gonna rule on today. We're gonna rule on that when it comes time. If it's not worked out prior to the hearing, we're gonna rule on that at the hearing. So we're not gonna do a rule on a motion and eliminate. At least that would be my position. I don't mean to speak for everybody else, but I mean, that's not generally how we would handle something like that. So we have your list of documents you want to exclude. I don't want you to necessarily go through each one of them now.
Okay.
And we'll discuss that in our executive session, but generally that's the sort of thing we would wait until we're in the context of the hearing to make a ruling. So let's talk about the witnesses.
Some of the witnesses that they were listed, they are not relevant to the 200 suspension. Number one, the person who makes the decision is Colonel Lamar Davis, who is the one who has the authority, who is the appointing authority. He is the one who makes the decision. Number two,
But he didn't make it in the abstract, right? He relied on people to provide him information.
that's correct, but those people who are listed as witnesses, we didn't oppose to that. So what we wanted to do is to limit it to this case that is before the commission, which is the 257S. The people that they were listed, they have nothing to do with either the investigation or the decision for the suspension of the 200 hours. And that's the reason why we wanted to limit it to those who are actually involved in the case.
Anything to add to that?
No.
Relative to the witnesses.
Okay. I took the time in our opposition not to just paint with a broad brush and say, gee, they're not relevant into 401, 403, but I identified in very general terms why they are relevant. You have before you, as I indicated when we started this morning, the recordings. And had I looked at these notes, I could give you dates. The recording of Troy Pichon was on 6/9. The recording of Leander Journay was 6/8.
What year are you talking about?
2021. And the recording of Kenny Van Buren was, at least I think there were 2 recordings of Mr. Van Buren, were around June 4th, 2021. I don't have the date on the other one. But here's kind of in broad brush strokes. Troy Pichon in his recording that was made on June 9th, 2021, both he and Leander Journay in their recordings said the following things. Journay admitted to having personal knowledge about, quote, a couple of people, that's from the recording, at LSP, sitting down and trying to figure out what policies Mr. Cavalier violated about Mr. Cavalier's book, and basically trying to figure out how to get Mr. Cavalier out of state police. That was on 6/8. Mr. Pichon also in his recording, which was made on 6/9, used words to the effect, and I don't have the quotes in here, I apologize. But that he had been instructed to call Mr. Cavalier by Mr. Cavalier's supervisors and Mr. Pichon's supervisors. And that Mr. Cavalier needed to act in a particular way, i.e. stop reporting and complaining about police brutality and racism in order for him to not be disciplined. That's kind of the nut of it, in addition to which I think Mr. Cavalier told you that he was told to, quote, lay low. He obviously didn't, and this is what happened. Lieutenant Crane, in addition to what my client already told you about, we have text messages from Lieutenant Crane, which predate, I believe, June 4th of 2021. In the text messages, Lieutenant Crane is asking my client who he thinks should play him in the movie that would be made from my client's book. The reason that's important is because Lieutenant Crane was 2 steps above my client in the chain of command. The discipline we're here about 200 hours is that he wrote a book and he didn't have secondary employment, theoretically, didn't have secondary employment approval. Well, here's his supervisor laughing about when your book comes out and it becomes a movie, who you think's going to play me? And I think he even gave a suggestion as to which actor would play him in the movie. It underscores the fallacy of this disciplinary action to me in the strongest possible terms. It also lends credence to the recorded statements about, look, they're trying to find a way to get you. Lieutenant Draper Crane, in addition to that, you all know from my client's testimony this morning that he was intimately involved in the communications that were to the governor, Mr. Reeves, the Toussaint Louverture emails, and then, of course, having exact knowledge of the book and what it was about. That's also in my brief. Also, my client contends that he received a text from Lieutenant Crane on October 5th, 2021, that he was angry at Mr. Cavalier for what Mr. Cavalier had engaged in at that time. And if you'll remember, that was 25 days before Colonel Reeves left. In the text message, he talks about being angry at Mr. Cavalier for Mr. Cavalier speaking out about the issues, which were the racism and police brutality. He accused Mr. Cavalier of betraying state police, that Mr. Cavalier needed to stay away from state police, that Mr. Cavalier, excuse my language, quoted, brought the shit on himself in reference to discipline that was coming. Mr. Cavalier should have kept his mouth shut. Lieutenant Colonel Chavez Cameron and Lieutenant Colonel Kenny Van Buren, we talked about Mr. Van Buren in both recordings about what he was saying specifically with respect to my client about the leaker, that there was this notion among the command staff to try to take action against Mr. Cavalier in January of 2021. That was at least 3 months ahead of time when it comes about to the book time. That about LSP's investigation into Carl's identity / as the leaker. The command staff meeting, which I understand occurred on June 4th, 2021. The decision to discipline my client, both Lieutenant Colonels Cameron and Van Buren received Mr. Cavalier's emails we spoke about earlier, including those sent, and we have all the dates. It was October 16th, the 29th, November 10th, November 14th, November 30th, and January 12th of 2021. Both were specifically identified as witnesses about the notion of Mr. Cavalier being the leaker and complaining and trying to find some reason to discipline him, i.e., at least for the first go round, the 200 hours. Lieutenants Cameron and Van Buren also exchanged numerous text messages with Mr. Cavalier about his job, many of which Mr. Cavalier kept. And as I indicated, has produced in the federal lawsuit. So I don't know why all these people seem to not know what was identified in the initial disclosures. And then with respect to Captain Salim Alamin, he was my client's supervisor at the time the disciplinary action was imposed. So I'm not sure how he's not relevant since he was involved in the decision as my client's supervisor. And then Captain Laverdane's testimony is very similar, as I understand that we anticipate from Colonel Chavez, Cameron, Kenny Van Buren, and others, including Leander Journey, as it related to the disciplinary action at issue here, the 200 hours for writing a book and allegedly not having approval to engage in secondary employment, even though the guy 2 steps above my client was talking to him about who was going to play him in the movie about the book. So for those reasons, we ask that the motion in limine as it relates to the witnesses be denied. And I'm with you, Mr. Chairman. Those issues really can be handled at the hearing. If I get off and start asking them about the price of eggs or tea in China, I get it. That's not relevant. My intention is to get in here, get the relevant evidence on the record and move on. Thank you.
Your response.
Any questions? Any questions?
That's all the motions. Did you have a motion also?
I did, but I waived it, but I wanted to make sure,
Okay.
because we produced this stuff.
Oh, yeah.
But one of the things I did not get to tell you this morning, and I should have asked Mr. Cavalier, one of the items that was subpoenaed from him were instances where he identified himself as Elijah Steele on social media. What he indicated to me was that he did so starting in, I believe, 2015 and 2016. It was one of his pseudonyms that he used frequently on social media. When he adopted that pseudonym in 2019 for his brief stint in narcotics and undercover work, state police specifically gave him an instruction, go back and comb through social media and take anything out that calls you Elijah Steele. Because if you're dealing with a drug dealer, for example, they got computers too. And so he did that. So the only thing that we had is what we turned over to you. And I wanted to make sure that was clear on the record. He did what he was supposed to do in 2019.
That's part of this production?
Yes,
Okay.
yes.
So what are the motions?
I'm sorry?
We have a point of order or something.
When we're finished with this hearing, yes. Okay. Ms. Kraft, did you have a motion also, other than that?
No,
That's it?
sir. I think mine have been handled.
Now, if the parties want to address the issue of the penalty on the contempt, which is also something
With LSP.
with LSP?
Come back.
Your Honor, I think our argument is very clear. We did a very good faith effort to attempt to comply with what was requested of us. We did not do this in bad faith. We make good faith effort out of 5 questions to answer 3. As you can see from the testimony of Mr. Derek Williams, that's very something that we cannot we don't have the manpower to do. So it's not something that we disregard,
Is there any estimate of how much manpower it would take to call for those documents?
Could imagine it's going to be
I
my
want
extensive.
imagination. I want to know if there's a good faith effort to give me an estimate of what it would take to go through those documents.
As you may recall, even with the state police, there's a lot of openings, that's just going on everywhere. It's with COVID that is coming up, people looking for employment, it's going to take a lot of manpower to be able to do that. And working for the states is not something that is easily available.
Anything else relative to the penalty?
That's all we have.
Ms. Kraft, any comments relative? to the penalty?
No, sir, I think that's uniquely your decision.
I think that is all of the motions that we want to hear before we take on the executive session. Entertain a motion to go into executive session.
Move, Mr. Chair. Second.
Let me just make sure we're clear for the public record rules. It's relative to matters number 4 and 5 on the docket, and we're going to be discussing this kind of. Moved and seconded. Discussion. Take a roll call vote, please.
Ryan Crawford.
Yes.
Hunter Knapp.
Yes.
Monty Montalongo.
Yes.
Harold Parit. Jared Ricky.
Okay,
Bill
you
Simeon.
did this,
We're now in executive session.
Jason, you ready?
Yes.
Ms. Burns, you ready? All right. Executive session and come back in the public meeting.
I'll move. Second.
Moved and seconded. Take a roll call vote, please.
Brian Crawford,
Yes.
Leonard Neff,
Yes.
Monty Montalongo,
Yes.
Harold Parade,
Yes.
Jared Ricky,
Yes.
Eula Simeon.
Yes.
We're back in regular session.
Before we head into a discussion of items 4 and 5 on the agenda, I understand Mr. Unglesby had an issue he wanted to get straight before we broke last time. I understand y'all had met and that issue has been straightened out relative to some documents you were questioning whether you had. Okay, great. All right, with that being resolved, we'll move into any public discussion of items 4 and 5 on the agenda. Do you have any motions?
Yes. Mr. Chairman, I'd like to make a motion in the matter of Carl Cavalier, Department of Public Safety and Corrections, Office of State Police, docket number 21-257-S. We have a number of motions here before us. The first one I'd like to deal with is dealing with Kevin Reeves. And that was a motion to recall subpoena and eliminate rule to show cause regarding contempt. It was filed by Mr. Reeves' attorney. And in connection with that, I would like to make a motion that we motion to quash the subpoena would be denied, or to call the subpoena be denied, the motion to quash, and that we issue admonishment for failing to appear at the hearing itself. And that I think that's it. That's it on that motion.
Okay, so this is relative to the motion to have quashed the subpoena and withdraw the finding of contempt.
That's correct.
Okay. Relative to the motion to recall the order and finding of contempt, the motion is to deny that particular motion at this point. Do I have a second?
Second.
Been moved and seconded. Any public discussion?
Yeah, Mr. Chairman and Ms. Feeney, I want to be clear on this motion. So how do you interpret the current
So-
motion?
So it's a motion to quash or recall the subpoena. First of all, that's one thing, which is Mr. Reeves has been subpoenaed to appear at the hearing on July the 28th. And so if you quash the subpoena, then he does not have to appear. If you deny the motion to quash, he does have to appear at the hearing on July the 28th. Am I making sense?
Yes.
Yeah, but your read was a little different than my read of what
Right.
was being said. So
Okay.
why don't we just go with your reading?
What did I just say?
And we'll take that matter up at this point. So why don't you restate what you would have us vote on?
So the first would be whether you would move to quash or recall the subpoena, which would require that Kevin Reeves not appear at the hearing on July 28th. That would quash the subpoena that's causing him to appear.
So I would so move,
Okay,
or change my amendment to change my motion to make that clear.
Just from a procedural standpoint, do we want to handle the earlier issues? The earlier issue stems from first the finding of, that's fine, we'll go with that. It's been moved and seconded. Any discussion?
it hasn't been
Oh, I'm
seconded.
sorry.
Second.
Now it's been moved and seconded. Any discussion?
That is, just for clarity, that is just a motion to recall or this to.
Subpoena.
The subpoena.
That's correct. Thank you.
So you got to finish.
I'm gonna have some comments on it, but let's make sure everybody's on the same page on what we're doing. So it's a motion to, we have a motion to recall the subpoena.
Yes.
And it's been seconded.
And it's been seconded. And during the presentation of the evidence in this case, there were some arguments on whether or not former Colonel Reeves should be a witness in this case. The arguments were, in essence, that under his administration, there were, and the investigation into Carl Cavalier. And that investigation may in fact have led to the discovery of evidence which was later used in the administration of penalties, in this case, in an arbitrary and capricious manner, was the argument that was made. And we certainly heard some evidence that there may have been some inquiry into a leak or a leaker or whatever the case might have been during the latter part of Colonel Reeves's administration. However, I heard no evidence to indicate that there was anything that was discovered during Colonel Reeves's administration that was tied to Trooper Cavalier. So I still have a serious question in my mind as to the relevance of what former Colonel Reeves would have to say. And so I intend to support the motion to the extent that it would quash the appearance at the upcoming year. Any other discussion?
Off the question.
All in favor?
Aye. Aye.
Any opposed? The ayes have it.
Mr. Chairman, in connection with the contempt and the penalty associated with that, I'd like to make just a motion to admonish Colonel or former Colonel in this matter for his failure to appear at our April 14th, 2022 hearing.
So implicit in that would be a motion to deny his request to reconsider the imposition of contempt.
That's correct.
Do you have a second? Discussion. So an aye vote means that we sustain the finding of contempt. And the penalty that would be issued would be an admonition relative to the failure of former Colonel Reeves to have previously appeared. All in favor?
Aye.
Any opposed? And we've discussed this. We've managed to witness this last time. We understand that Mr. Oglesby admitted last time that it was his mistake not to file the motion to quash. He sent a letter in. It's our understanding, based on the representations of Mr. Oglesby, that he advised his client that he would not have to appear because of the previous conflict, despite the failure to comply with the rules on how to quash that subpoena. And that is the reason we are limiting our imposition in this case to an admonition only. You were acting under advice of counsel, and we understand that. And I accept the fact you haven't testified on this, Colonel Reeves, but I do know from past experience, you have a respect for this body, as well as a respect for state police. And I believe you would not intentionally have violated our rules and our requests and demand that you be here. But witnesses do need to be aware that when this body issues a subpoena, it means it. And that witnesses do have to appear. And if there are legitimate reasons why that witness does not have to appear or can't appear, that needs to be brought to this body's attention. We also, in my opinion, at least I of the opinion that an admonition is sufficient in this case, considering the additional evidence that we received today as to what appears to be a lack of relevance of this witness. That doesn't change the fact that the subpoena was violated. But because of the lack of relevance of what would have been presented, we limited the penalty to an admonition. Any other commissioners have any comments? Thank you. You're good.
Did we vote on it?
Yeah, you did.
We voted. Okay. Next. The next
Commissioner Knapp, I'm sorry.
motion before us was a motion in limine filed by Jason Turner to establish the areas of examination. I would move that that be denied, that we can make those decisions at the time of the actual hearing itself as to what we want to hear and based on the evidence and where we are. So I would deny that motion in limine.
Second, Mr. Chair.
It's been moved and second. Any further discussion? This one. All in favor?
Aye.
Any opposed? The ayes have it, so the motion is denied with the understanding that we'll rule on what evidence will come in at the hearing itself. Unless there's something else determined and worked out between the parties prior to the hearing with the consent of our legal counsel.
Mr. Chairman, with regard to Jason Turner, also, I would request when following his request that we defer the penalty until after we make the decision dealing with this matter. And I would defer any penalty until that time.
This would be the penalty on the contempt.
Penalty on the contempt. That's correct.
Been moved by Commissioner Knapp. Do we have a second? Commissioner Paris. Any discussion? All in favor?
Aye.
The ayes have it. Any opposed? Thought I only heard ayes coming back. So, all right, the ayes have it. Do you have any other motions?
I have a few more, Your Honor.
Now, you know I'm not a
With regard to the Louisiana State Police, there was a motion to recall the subpoena and eliminate the rule to show cause regarding the contempt filed by the Louisiana State Police themselves. On the motion to recall the subpoena and eliminate the rule regarding the contempt, we'd like to defer that. I move that we defer that until till later, that we would ask the parties, first of all, the state police, Louisiana State Police, to maintain the documents that were created by it was the search of something like 7.2 megabytes is what I wrote down, I think. Gigabytes to kick it up a little bit. But that we asked the parties to get together by June the 17th to limit their search request or production, and with that to meet with our attorney within 10 days after that June 17th, 2022 deadline, if they have not resolved that issue dealing with the production, and then we'll have if there's any dispute about that, it'll come before the commission at our July the 14th meeting to cover that, any further disputes that need to be resolved by this commission.
Take it implicit in your motion, Commissioner Knapp, is that if the parties come up with an agreement as to the search terms, although the documents originally searched will be maintained, there won't be an opportunity to seek additional documents other than the documents that are disclosed pursuant to the new search terms.
Yes, we've got to, yeah.
So-
that's implicit in that.
Do we have a motion, a second? A motion and a second. Any discussion? I would just ask that the parties get together both sides. It's going to take some work on the front end to try to resolve this. We need input from the department as to what the problems are that it would have. We need input from the requesting party, but the requesting party already made their request. The department needs to meet with them and try to work that out. And we need y'all to work together to try to narrow this, because obviously you're talking about millions of pages of documents right now, which many of which may or may not be relevant. We haven't ruled on that yet, but we need the parties to work together instead of bringing it to us to try to solve this problem. If y'all cannot work together, I understand. Thank you. I understand, but you got to work at it before you come here. Okay. All in favor?
Aye.
Any opposed?
Chairman.
And unfortunately, that means if y'all don't work together, we're going to issue a ruling. As much as we don't want to have to be the ones to issue that ruling, that's going to tell you what the appropriate scope of the discovery is in this case. But we would rather the parties try to solve that problem before we solve it for you. But once we rule again, it's not going to open, it's not going to reopen this whole thing to another set of documents later. It's going to be limited. So work together. Thank you. I'm sorry.
Mr. Chairman, one more thing is the rule to show cause regarding recall of subpoena and eliminate the rule to show cause regarding contempt. That should be deferred until July the 14th, 2022.
Relative to the department.
Relative to the department. That's correct.
Second.
Comments? We certainly will defer that, particularly the imposition of the amount of sanction or the scope of the sanction until then. I'm just telling you personally, I'm not inclined to change the position I had last time. That it was contempt at the time that it didn't comply with, because there was no effort at that point to try to narrow the scope of it. That's just my personal view. I'm not expressing the view of anybody else, but yes, we will consider those issues at that time. But we have
haven't voted.
Any other comments? All in favor?
Aye.
Any opposed? The ayes have it.
The other motion that I have is a motion in limine to exclude evidence that was made by the Louisiana State Police regarding this. And I would move that it be denied without prejudice to make it during the actual hearing itself regarding the evidence that we'll consider. I think that has to be made at the time.
Been moved in second? Moved in second. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. That all the motions you have, Commissioner Knapp?
I think so.
Hope so.
Ms. Feeney said she hopes so. Relative to item number 6 on the agenda, public hearing to consider proposed rule changes to State Police Commission rules. I will make a personal motion that we defer that to our July 14th meeting. Personal reasons, I asked that be done.
A second.
Any discussion? All in favor?
Aye.
Any opposed? The ayes have it, which brings us to item number 7. Or Dwyer.
Commissioners, please indulge me for just a moment. Before you tell me how much time I have, let me make a few prefatory remarks.
No, I'm not going to let you make a brief prefatory remarks, then tell you how much time you have. I will just tell you this. You are a party presenting a motion. You present it adequately without being overly burdensome on our time. That's your limitation.
Thank you, and I appreciate that. Gentlemen, before I begin my substantive presentation, I want to tell you that I'm not here to throw hand grenades. but I do have what I consider to be very important issues to bring to this august body's attention. I'm going to give you a thumbnail sketch of what I'm going to tell you today by saying that the evidence that I'm going to present to you and have presented to you shows an institution, the Department of Public Safety and Corrections, Office of State Police, as an agency in disarray. Particularly, what I'm going to show you gentlemen today is going to demonstrate that the Louisiana State Police is a racketeering enterprise. I know those are inflammatory words, but I didn't make the facts. The facts have been made for me by that body. I'll mention a few names before I get into the substance of my presentation. Reeves, Noel, Kane, Flincham, and Morrison. Remember those names. What do they have in common? They have in common.
And Mr. Dwight, I'm gonna let you do your presentation. I just want to make sure we're all on the same page as to what the authority of this commission is. This commission has authority to take appeals relative to discipline of classified employees. This commission has authority to issue discipline for a violation of our rules relative to classified employees. And this commission has time limits within which it can operate. So, but subject to that, I just want to make sure we're on the same page.
I understand all of that. But in direct response to your observation, Mr. Chairman, I would merely state that because an individual is no longer in the active state police service does not mean that you are constrained from asking questions of and about that individual in order to determine whether or not this commission rules have been violated or whether rules have been violated by the Office of Public Safety and Corrections, Office of State Police. That's all part of my presentation. And while we're on that subject, I know and you know that Colonel Reeves has retired, that Chief of Staff Kane is still in the active service, and I'm going to give you another name that I didn't know until May the 26th when Captain Manali divulged it to me that he's still employed by the state police, John Nelson. His name will come up again in a few minutes. He remains on active service. He's a sergeant now. He was a trooper when I was brutalized. I know that Ms. Morrison appeared before this body for years, maybe not before you gentlemen. I don't know how her term as with the Office of Legal Counsel coincided with your own, but she appeared here many, many times for years. And I don't think anyone ever asked her during any of her representation of the state police about her obvious conflict of interests by virtue of the fact that her husband was a ranking state trooper the entire time. Mark Morrison, he may not be on the force any longer, but he was a major when he retired or left the service. And it's ironic that that her name figures prominently in what I'm going to tell you all today. And it would be very ironic that, you know, a technicality
Well, she wasn't in the active state police service, so therefore we had no jurisdiction over her when she appeared before you all for years, representing the state police. All right, I've gotten that off my chest. I want to start off by telling you gentlemen, I'm not here to throw hand grenades. I'm here to help you discharge your sworn duty. I don't know any of you personally, and I concede that I believe I owe each of you an apology. I went back and I read in preparation for the day what I submitted to you, styled formal charges, requests for investigation, and exercise of empowerment, which although dated February 14, 2022, was actually perfected when the mail was picked up from the post office box here in Baton Rouge on February the 18th of 2022. I used some language in that formal charge and request for investigation that was inflammatory, and for that, I apologize. I believe each of you to be an honorable man, borrowing from William Shakespeare's Julius Caesar. And I know, because I heard the oath that the new member took this morning, that you all will faithfully do what must be done to discharge your obligation under that oath. Now, what I'm here to talk to you all about today is a common denominator between my case and the Ronald Green case. I use the term racketeering enterprise. I know there are at least a couple of lawyers on the panel, and some of you have law enforcement background. I know that you've heard the terms before: pattern of behavior, standard of conduct, modus operandi. I don't know what other buzzwords I could use. Oh, predicate acts. Denominators between my case and the Ronald Green case are, remember the names that I gave you all: Reeves, Noel, Kane, Flinchman, Morrison. Remember the terms cover up. Why are we here today? I'm not here today to talk about, excuse me, you all said on your agenda that you're here to discuss investigative proceedings regarding allegations of misconduct, namely that the state police engaged in criminal conduct and violated his civil rights in the aftermath of Hurricane Katrina. That was 17 years ago. That's not what I'm here to talk about today. You've heard the expression, it's not the crime, it's the cover-up. Focus on the cover-up aspects, although you've got to know what happened to me in order to understand the big picture. What was done to me and what was done to Ronald Green were both horrible. He died. I was only pepper sprayed 30 to 40 times while my hands were cuffed behind my back. I was only shot in both thighs a total of 12 times at point blank range with a 12 gauge shotgun loaded with beanbag rounds, while my hands were cuffed behind my back or behind a Guantanamo style dog cage. Did that to me. I was abducted from my home by, guess who? F Troop. Where have you heard F Troop before?
Who murdered Ronald Green? F Troop. From where? Monroe. Who came to my house and abducted me for nothing because there was nothing illegal happening on my property? F Troop. In 17 years of litigating and adjudicating in legal and quasi-judicial proceedings with the Louisiana State Police, I was given a grand total of 2 names and 1 scrap of paper. 17 years. Got the name John Nelson, who was a state trooper, badge number 2227. And I got the name Christopher Ivy. Got 1 piece of paper. Names and 1 piece of paper in 17 years to the blue code of silence. But I don't attribute it to that at all. I attribute it to what I call predicate acts, a pattern of activity or behavior, standard operating procedure, modus operandi, MO, and cover up. And it is no coincidence that the Louisiana State Police, through Colonel Davis, Ms. Gail Holland, who ain't here today, and Captain Manali, is in default on a Louisiana Public Records Act request that I submitted to them on February 5th, 2022. I've gotten nothing from them since then.
You do realize that there are laws that govern Louisiana Freedom of Information Act and public records requests that we don't have jurisdiction over. You take that to district court, and district court will enforce those laws and issue whatever is appropriate
Yes,
under those laws.
I understand that. And I'm telling you that they are in default. The item number is OLA 076476. In short, I'm being stonewalled again, okay? Now, what is a policeman? Authority no less compelling than the Supreme Court of the United States in a 1968 case, name of which is Broderick versus Gardner. I don't know if you've ever heard of it previously. But in it, Abe Fortas, who was a liberal, I'm a conservative, but you've heard of Mr. Justice Fortas, said, a policeman is directly, immediately, and entirely responsible to the city or state, which is his employer. He owes his entire loyalty to it. He has no other client or principal. He is the trustee of the public interest, bearing the burden of great and total responsibility to his employer. Unlike the lawyer, he is directly responsible to his client. The policeman is either responsible to the state or to no one. Is the state with respect to the Louisiana State Police? Well, gentlemen, you are the Louisiana State Police Commission. You took an oath to uphold the Constitution and laws of the state and of the United States. You are the state. Nobody stands between the policeman and the public except you. And that, I respectfully suggest, is an awesome responsibility. Why do I bring that to your attention? Because just as Mr. Chairman stated very accurately, without any disagreement from me, that your article and rules vest in you the power to investigate, cases of criminal misconduct by state policemen, individuals, but the quote, Office of State Police within the Department of Public Safety and Corrections. In this case, where the appointing authority, and I'm talking about my case now, refused to act. A few minutes at Reeves, it actually started with Edmondson and Dupuy. Edmondson, Dupuy, Reeves, Noel, Kane, Flincham, and Morrison, to whom I reported not only misconduct, but criminal misconduct, refused to act. In essence, told me, go fly a kite, O'Dwyer. We're not acting on your complaints. When that happens, you are the only body that I can come before. And I'm going to show you that I actually made the attempt. On through your rules, your article and rules very carefully. And I submitted to you all, in addition to the formal charges that are embodied in that February 18th, 2022 submission, a lengthy written submission that I gave to Mr. Hanneman, which each of you should have access to today. There's a copy for each of you. That's my written presentation. It's 52 separately numbered paragraphs. There are 4 additional exhibits. That is, in addition to 1 through 9 that were submitted to the original formal charges, you've got 4 more, 10 through 13. Those things constitute evidence. Please, gentlemen, in your leisure time, when you are doing your sworn duty, please read my materials. I'm not going to read all of that to you today. I'm keeping it as short as I possibly can. But the analysis of your rules falls within paragraphs numbers 13 and 21. I don't claim to be any smarter than any of you are. But if you want to take a look at a good summary of your rules, which lay out in black and white the power that you all hold under the Constitution, article, and rules, read my numbered paragraphs 13 through 21, excuse me. Particularly Rule 2.9C, which I'm going to read to you right now, which empowers you to conduct investigations. Remember what the chairman told me. I agree with him 100%. Whenever it has reason to believe the provisions of the state police service article or rules are being violated or have been violated by any person, says, or Department of Public Safety and Corrections, comma, Office of State Police. A very, very broad grant of power conferred by the provisions of Rule 2.9C. Make sure that that is emblazoned in the fleshy tablets forevermore. Now, I'm going to sound like a broken record, but the above referenced article and rules are breathtakingly broad in scope and demonstrate that you enjoy great power should you choose to exercise that power, which vests in you. I'm not going to read it again. Rule 2.9C. to conduct investigations when it has reason to believe that the provisions of the state police service article or rules are being violated or have been violated by any person or Department of Public Safety and Corrections, Office of State Police. Now, I said that we're here to talk about not what only happened to me, but also what happened to Ronald Green because the same MO for covering things up was employed by the same people for the same purposes, cover up. The common denominators in the Green case and my case being F troop and cover up. Brought the Green case to my attention. Why should Ashton O'Dwyer, who was brutalized with his civil rights being violated by the state police F troop 17 years ago, why should that grab his attention recently? Grabbed my attention because I heard the names Reeves, Noel, Kane, Flincham, and Morrison being brought up before Tanner McGee's House committee investigating the circumstances of the death of Ronald Green time and time again. I was reading Mr. Tom Aswell's blog, Louisiana Voice, and I saw these names and I said, wow, this rings a bell. And sure enough, I remembered that in my own case, after I had brought to Colonel Edmondson's and Colonel Dupuy's attention the violation of my civil rights back in 2017, back 17 years ago, excuse me, in 2005, I brought those things to their attention in 2015. The guy who was running the show at that time, a DA from Monroe named Fred McGahey, who interacted with F Troop all the time, he takes Nelson's deposition, and guess what? Nelson lies at his deposition. He commits perjury. And I said, wait a minute, he can't get away with this. He's a state trooper. He lied at a deposition. I got to let the state police know about this. I got to let them know that this guy not only lied at a deposition in 2015, he brutalized me back in 2017, 2005, pardon me. Together. And I submit it to Colonel Edmondson and Colonel Dupuy, who don't do diddly squat with it. So in frustration, the change of the guard is about to happen. And I find out about the existence of the Louisiana State Police Committee. And I write a letter to Ms. Dearborn. That is exhibit number 10, which is in the submission that I gave to Mr. Hanneman today. We're on the telephone, and I explained to her that Colonel Edmondson, Colonel Dupuy, and Ms. Flincham are all conspiring, along with Assistant District Attorney Fred McGahey of Ouachita Parish, to obstruct justice and cover up the wrongdoing in my case. Accordingly, Ms. Dearborn, I am requesting an independent investigation of my allegations against Nelson. This is all laid out in O'Dwyer Exhibit number 10, which Mr. Hanneman has and which you will have shortly. It doesn't take her long to act on my request. What did she tell me? By letter dated July 21, 2016, which is A-Rod Exhibit number 11, she says, quote, "We have reviewed your complaint today, wherein you requested an independent investigation pursuant to Chapter 16 be initiated to investigate the allegations of 1, a violation of your civil rights, 2, perjury by a member of the state police service during a deposition, and 3, conspiracy to obstruct justice by the superintendent and assistant superintendent. Pursuant to SPC Rule 16.1, any person may file with the director of the commission written charges. Unfortunately, the alleged conduct is not governed by the article of the rules. He brushed me off, just like Colonel Edmondson and Colonel Dupuy brushed me off. Now I ask you, if I can't get the colonel and the lieutenant colonel to act on the investigation of my complaints, and I can't get the commission to act on the investigation of my complaints, who can I ask to act on the investigation of my complaints when the governing authority has dodged the issue? What is the remedy? Back to you all again today.
We've
And
been
I'm-
going in excess of 25 minutes now.
All right, I'm gonna.
I want you to have full opportunity to address this.
I understand and I sincerely appreciate it. I sincerely appreciate it. Where we are in my presentation right now is I've identified for you who brutalized me. I have identified you who failed to act in my case. I have identified to you who attempted to cover up things in my case. I told you that we are here because of the similarities in my case and the similarities in the Ronald Green case. Who are the Ronald Green cover-up artists? And I mean no disrespect to the commission, but unless you gentlemen have been living under a rock, it should be apparent from the publicity that particularly the McGee investigation has uncovered, which is still being uncovered, and which has been written about at length by Mr. Aswell on his blog and by James Gill in The Advocate in an article that I cited to you all, that in the Ronald Green case, certain current and former state policemen participated in a massive cover-up about what actually transpired on a state highway in Washita Parish, in Union Parish on May 10, 2019. Who are they? They are Reeves, Kane, Noel, Flincham, and Morrissey. Who are the cover-up artists in my case? I submit to you, they are Reeves, Kane, Noel, aided and abetted by Flincham and Morrison, just like in the Reeves case. Doing what? Engaging in a systematic pattern of behavior by the commission of predicate acts in accordance with standard operating procedure, a modus operandi to cover things up. It happened in my case, and it happened in the Ronald Green case, and it involved the exact same people employing the same MO. Where does this leave us? And we're coming to the end, I promise you, Mr. Chairman. Number one, just suppose that the Louisiana State Police top brass, like Edmondson, Dupuy, Reeves, Noel, and Kane, had acted on my formal charges and request to investigate when I first submitted that request to them. Suppose they had acted. Might the rank and file, including the guys at F Troop, have gotten the message that serious allegations of criminal misconduct of any type would be dealt with swiftly and decisively instead of covered up as usual? Ditto for legal counsel Faye Morrison, who was appearing routinely before this body, although she may not have actually appeared before any of you gentlemen because her term and your terms didn't overlap. Nobody even raised her conflict of interests with her. This is the same Faye Morrison who Mr. Aswell recently wrote is involved in rehiring cadets from the training academy who were fired because of their involvement in a cheating scandal. Have you all done anything about that? Do you know about it? Had failed to act. Suppose Ms. Dearborn had acted when I sent my letter to her back in July of 2017. The brass hadn't acted within the state police, but the commission did. Would the rank and file have gotten the message that included F Troop that covering things up and engaging in criminal acts was verboten, and that if the brass wouldn't do anything about it, you guys would, because you have the power to investigate any person and the agency itself? Of course, those questions all lead to the most obvious next question, namely which is, had Ms. Dearborn acted and the commission acted when she failed to act, might Ronald Green be alive today because the guys in F Troop would have thought twice before what they did to him on that state highway in Union Parish on May 10, 2019. Now we get to the end. Rule 16.5, which says that you gentlemen may go into, or you should go into executive session. Rule 16.5 is very, very broad. This is another one that should be committed to your memory and emblazoned in the fleshy tablets. It says, once you go into executive session, you have the sole discretion to take any action as it that you deems appropriate. In its sole discretion, the commission may take any such action as it deems appropriate. That is very, very broad, gentlemen. I'm not going to invade your province by suggesting to you what you should do. You're the ones that took the oath, not me. But you all have an opportunity here that most of us don't get, and that is a second chance. We're now presented with another opportunity to take action. The rhetorical question is, will the commission fish or cut bait? What am I telling you? One, I'm telling you that I believe the commission has original jurisdiction to determine a state police disciplinary matter involving an individual trooper, no matter what his rank is, particularly where the appointing authority and the Office of State Police have failed to act and obstructed justice so the matter could remain covered up. Number two, I believe that you have original jurisdiction to conduct investigations whenever you have reason to believe that the provisions of a state police service article or rules are being violated or have been violated by any person or Department of Public Safety and Corrections, Office of State Police, the institution itself, gentlemen, and to issue appropriate orders in any such case. And even if the commission has never utilized its original jurisdiction, that does not mean the commission lacks the power.
One more minute.
Look at the power enumerated in paragraphs 13 to 21 of what I submitted to you in writing. And that includes the power to ask questions of anybody you want, whether they're currently in the state police service or not, in order to enact your powers or discharge your duties under your powers. And if the commission fails to act in the face of no action whatsoever by the state police except obstruction of justice and cover-up, then who will the policeman, state police, which is the trustee of the public trust, be required to answer to and be responsible to? Who the Supreme Court has said is answerable to the state. Who will that policeman answer to if not you, gentlemen? That's the end of my presentation.
Thank you, Mr. O'Dwyer.
I hope it's made an impression on you. I have one more thing to say.
That'll be very quick.
I don't control what you all do in executive session, but I am available to answer any questions that you wish to put to me 24/7. I'm reachable by telephone or email at any time, day or night. I've also been told that it is even within your province to decide the matters that I have presented to you here today in public session rather than in executive session. I don't know what rule that is, but that's what I've been told. Perhaps you know. I don't want to step on any of your toes here. I'm making myself available to you to try to assist you in any way you think I can to help you reach a just and right decision in this case.
Thank you, sir. Commissioner Knapp.
Mr. O'Dwyer, did you present the same thing to the Louisiana State Police Commission in July of 2016?
Yes,
And did you appeal the decision? It appears that that you requested an investigation and it was denied. Did you
yes, Mr.
appeal?
Hanneman has that correspondence.
I have it. We've been presented that.
All right,
Did you appeal that decision to the appropriate court?
no, I never went to court. I did not go to court.
So
Ms. Dearborn, I respectfully submit, informed me or gave me the brush off erroneously. I am asking this body to revisit the same issue that was presented to Ms. Dearborn in 2017 in light of what has been revealed about the Ronald Green case and the similarities between my case and the Ronald Green case, and do the right thing this time. My last communication with Ms. Dearborn is embodied in my exhibit, A-Rod exhibit number 13, which is in the package that I gave Mr. Hanneman today. In addition to that, to get to your specific question, there was additional communication between me and Mr. Hanneman that I didn't give you guys, but which Mr. Hanneman has access to. Does that answer your question?
Mr. Hanneman, please.
Yeah, I'm unfamiliar with what you're referring to, Mr. What additional communication beyond the original documentation that's stems from your charges?
But beyond the
And then-
original documentation between me and Ms. Dearborn, I believe you and I exchanged some communications. I don't have my computer with me today in this room. I have it at the hotel, but I will refresh your recollection, Mr. Hanneman.
We'll ask Mr. Hanneman to search his, I'm assuming you're talking about emails, his emails or correspondence.
Well,
And if you have anything additional, you can submit it to us, but.
All right,
we'll look at it.
I'm trying to answer Mr. Commissioner Knapp's question. I don't know what's going through your mind. I don't know whether you're thinking res judicata, collateral estoppel. I don't know what you're thinking. I'm just trying to answer your question. There was additional communication after Ms. Dearborn and I communicated the last time. She shut me down.
Anybody else?
You all have an opportunity to do the right thing again.
Thank you, sir. Entertain a motion to go into executive session.
So moved. Second.
Moving second, roll call vote.
Ryan Crawford,
Yes.
Leonard Knapp. Yes. Monty Montalongo.
Yes.
Harold Parit,
yes.
Jared Ricky, Eula Simeon,
Yes.
for an executive session.
And before everyone leaves, why don't y'all just wait just a second? I want to kind of discuss.
Do I take it
entertain a motion to, Ma'am. Eddie Jason?
Yes.
Entertain a motion to go back into public session.
So moved.
It's been moved and seconded. We need a roll call vote.
Brian Crawford,
Yes.
Leonard Knapp,
Yes.
Monty Montalongo,
Yes.
Harold Parit,
Yes.
Jared Reekey, Eula Simeon,
Yes.
back in regular session.
And I make a motion that we take this matter under advisement. Mr. LeBron has given us lots of information that we need to go through. We need to ensure that we have before us, and I know we've been provided some, maybe all, but Mr. Hanneman is going to check to make sure that we have all of the information that you provided to him so that we can fully evaluate and review this matter. But we had your presentation, but we're going to take it under advisement, okay?
Thank you very much.
Thank you, sir.
Second.
Oh, I'm sorry, yeah. So we have a motion and a second. Any discussion of the motion? All in favor?
Aye.
Any opposed? The ayes have it. So you'll be hearing back from us. All right. Yes, sir, Mr. Burns. Now, to address the commission on matters not on the agenda.
On the agenda, you're
Gonna do a
first.
very abbreviated one.
Oh, you're right. I am going to do a very abbreviated. 42-point plan. That's briefly, commissioners, I just want to, in your tab behind, I think tab number 8 is the commission expenditures. We're wrapping up the fiscal year, and we will have an end of year report, should be by the July meeting. Questions regarding expenditures? Testing, we had the promotional exam on May 19th. We had 394 registered, but 358 actually took the promotional exam. In your binders, I have some of the data, the historical data regarding the 3 exams, as well as a chart graphing out the results of this exam in 2022. Overall, we trended, the scores trended higher, so much so that the sergeant pass point has increased from a 69 to a 73. And lieutenant and captain are commensurate with prior scores. The letters went out in the mail yesterday. So the tester should start receiving those probably as soon as today, which means we'll start having promotional opportunities come up and come available for LSB promotions. And we'll also, we'll start planning the November exam. So individuals can have a opportunity to test in November. Any questions regarding the administration of the promotional exam? On the agenda also, or on my director's report, just want to let you know that we budgetarily, we are whole as far as the recommendation we put forth for our fiscal year 23 budget. The funds have been added so that we can ensure we can post and recruit for a deputy director position, as well as complete our remodel of our current office space. The Department of Agriculture and Forestry, they've been excellent partners and worked with us on our remodel timeline. We should have our office space remodel complete, hopefully by our next meeting. And also, I've drafted a posting for a deputy director position. My plan is to post that position by next week so we can start gathering applicants ahead of the start of the fiscal year. And I'll reach out to anyone that wants to be on an interview panel. So, and then lastly on my report would be that our next meeting is scheduled for July 14th. And I believe we're going to start that at 9 a.m. Any questions?
See none. Mr. Burns, you have a request to address the commission on a matter not on the agenda.
Yes, sir, Mr. Chairman. It's Robert Burns, and I know it's been a long meeting, so I'll keep it brief, but I just feel like I would be remiss, given how long this is going on and nobody addressing it. And what I'm referring to is the LSP Academy cheating scandal. It's massive. It's involved entire classes. It's involved legacy classes. We're not talking about one or two persons taking the test for becoming troopers. Now, Mr. Hanneman spoke with me right before the meeting and wanted it made clear that this commission only administers the exams for someone entering cadet school as well as the promotional exams, and does not maintain the custody or oversee the actual exam for becoming a commissioned trooper. I appreciate him, and he's nodding his head, so I said it correctly, right? I appreciate him educating me on that. Nevertheless, you're the only people I know of that can look into this and do something, and hopefully do something about it. Retired Lieutenant Leon Bucky Miet, I know y'all are all familiar with him, even though he hasn't come to a meeting in a long time. In January of last year, he copied the commission on a massive public records request, and a lot of names are in there. He got the runaround. I'm sorry, I'm just going to say it from, I know he's mentioned Faye Morrison. She gave him the runaround, and I think he's seriously contemplating a lawsuit for the LSP's failure to turn over the records. Mr. As well, I thought you'd maybe bailed. He's written several fine articles on it. He's named names, but there are a ton of names. And I have been provided with highly credible internal documents. I don't like to use leaked documents. I really like to go about getting documents what I consider the right way, through public records request. But given what happened with Mr. Miet, I am going to exploit these documents. They are completely accurate. They're internal, and it is massive. And I'm just going to be blunt about this. From my vantage point, those folks who, they had full-blown copies of the exam, and that includes the post-exam. And from my vantage point, these folks are not troopers. They are frauds. And I don't back down from saying that. I think that can cause significant problems in a court of law for an attorney who brings up, a Brady motion. You can probably elaborate to that a little more than I could. Maybe it won't be that concerned, but I know I would try to exploit it if I'm a defense attorney. And I think it's a serious, serious problem. I know 2 members of the Green Committee have been provided with a massive level of documents, specifically Debbie Villio and also Tanner McGee. Why they have chosen not to address this to this point, I know Ronald Green is a focus of heavy emphasis, but in my opinion, this is a focus of heavy emphasis because it goes directly to the credibility of the troopers that we have out there representing us. And for this sheer number to have cheated and had the actual exam, not some study guide. I realized that was the narrative that was put forth by Doug Kane, a completely false narrative in January of 2021. And he knew it to be false when he put it out there. It's not only embarrassing, it's disgusting. So it would be my hope that this commission, you can get the names. I'll be publishing a lot of names, would bring forth these troopers, bring forth their superiors who willingly supplied them with flash drives with the questions, and have them account for their actions. So I know it was very late to have to make these comments, but I felt they were important enough. And I know it's been a year and a half since the magnitude of this cheating scandal first started to bubble up. And I think that's too long to have gone being unaddressed by any significant people with any authority, be it the legislature, y'all. It's everybody wants to bury their heads in the sand. Let's just pretend this didn't happen. It did happen. And it happened through a number of classes, going back very easily 5 classes. It involved legacy classes, legacy being defined as ones that involve the children of high-ranking state police officials. So that's my comment. I'm really hopeful that this commission will start insisting that individual troopers be brought in here and grilled on just what all happened. I don't know about being able to terminate them over this. But y'all are the only ones that I know of that can try to delve in and expose the magnitude of it, because it's not just one or two troopers out there. I mean, it is an awful lot of troopers. So thank you for indulging me this opportunity, and that'll be the end of me making comment today. Thank you.
Thank you, Mr. Burns. We appreciate you bringing that to our attention. Mr. Burns, would you please, Commissioner Knapp has a question for you.
Are you saying that persons got in advance questions that are, our tests are supervised online even? Did our tests get out for the cadets or for the promotional exam? No, that's not what you're saying.
That's correct. And I'm glad Mr. Hanneman clarified that. There's no evidence for, and I did not even realize that this, forgive my ignorance on that, that this commission did not oversee the examination for becoming a commissioned trooper, that it only oversees, I didn't even know there was an exam for being admitted into cadet school and promotional exams, which he just mentioned a second ago. As Mr. Hanneman has said to me, the actual administration of the final exam for becoming a trooper is solely handled within the academy. And there were supervisors, I could start naming them, but
I'm interested in just where the scandal is in what part of it.
And Commissioner Knapp, what I was clarifying with Mr. Burns is that the entrance to be considered for a state police cadet is handled by the State Police Commission, which is the entrance exam. That's the first hurdle to becoming a cadet. Once an individual is then, and so that is within the State Police Commission, that is controlled by us, and that is not alleged to have been uncovered or being used by anyone else. So once someone's selected to go into the academy, all the testing, there's all the drills, all the components to go through the 23-week curriculum. That curriculum is developed internally by LSP. They run their training academy. They then graduate cadets to trooper status.
Okay.
Which is what just happened last month, was the 50 troopers graduated. Once they serve, if they're 5 years, then they're eligible to become a sergeant or then promote. We handle all aspects of the promotional exam. And again, that's also not alleged to have been copies of. Those are controlled by the commission. The LSP Training Academy controls their internal processes for moving a cadet to be training and adequately trained and then graduate their academy.
So the alleged corruption occurred inside the academy itself.
that is correct, sir.
Okay, I understand.
To the extent that may involve classified employees within State Police Commission service, those people are subject to the jurisdiction of this commission.
That's correct.
Sure. And I will be publishing something. Tom has already published it, but like I said, I don't like to use leaked documents, but I now have one that's internal. It's authentic. It's got a lot of names. It's got a lot of admitted things that happened. In my opinion, Ms. Morrison should have turned this over when Mr. Miet made a public records request 1.5 years ago. She didn't do it. She can answer why she didn't do it. I know Mr. Miet is not just livid that she didn't, he's beyond livid. So I have it now. Unfortunately, I didn't even ask for it, but one of my most reliable sources dropped it on me about 2 weeks ago. So I have it. It's authentic. And unfortunately, I am going to use it. I would much prefer to have gone about it by making public records request and doing it that way. But, you know, I guess there's a little bit of Chris Nakamoto and Tom as well in all of us. So,
Well, thanks for bringing this to our attention.
all right, you're welcome.
Thank you.
Anybody else? We have a motion to adjourn in a second. Any opposition? Hearing none. We are adjourned.